Good morning, David. Mr. Albright, just checking in to see how the audio is.
It sounds good.
Okay, thank you, sir. Appreciate it.
Likewise, Mr. Lee, can you hear me?
Yes, sir.
Excellent. Thank you.
Mr. Lee, this is Peter Gould's computer. Can you hear me as well?
Yes, sir.
My partner Kelly will be conducting the meeting, but not quite ready to. So I'm gonna be on until she gets on, but we will only have one computer on. Thank you.
All right.
Peter, this is Jeff. That's reassuring. There for a minute, I thought we were not going to have um, Kelly's expertise, and we're going to have to settle on you being in the hearing this morning.
Well, as you can see, I'm ready to go fishing. So I can't find a tie. I don't know what it is. Just this morning, of course, I'm not. I'm not even caffeinated yet, so I shouldn't be talking to you. One time, I almost lost a client because I figured I'll call him real quick, and I hadn't had my cup of tea or coffee. It wasn't pleasant. Okay, I'm gonna save everybody the video feed.
Okay.
Okay, yeah, thanks, Jeff, and yeah, so we'll be. I understand that Cump is coming on later, so it's going to be kind of a in and out kind of day. Yeah.
Yeah, I think that ended up being scheduled for 2 this afternoon, I think.
Yeah, that's what I saw as well.
And Mr. Dauphiné scheduled for early afternoon, is that correct, or late morning?
Well, he goes on after Sandberg, so
Okay.
whenever that ends.
All right.
Yeah.
Mr. Sandberg, this is the court reporter. Can you unmute yourself and say something so I can check your sound level?
Good morning, Mr. Lee. How are you?
Good morning.
Is that
I'm
okay?
doing fine. Yes, sir. Thank you very much.
My pleasure.
Whenever you're ready, Judge.
Okay, I'm just admitting a few more people here. I'm ready. It's 9 o'clock. Good morning, everyone. I have a few things to mention before we get to the testimony today. I think we talked yesterday about having Mr. Sandberg first, Mr. Dauphiné next, then had a request from Commissioner Maestas late yesterday that he wanted to ask some questions of Mr. Kump. And so you've probably all seen a series of email string last night on that issue, which I guess seems to be resulting in Mr. Kump being available at 2 p.m. For questioning by Commissioner Maestas. And thank you, Mr. Haverly, for arranging that. I had one other item, though, related to the need for some further information. I was going through my notes and I was trying to get clarity about the independence of the PNMR board. I noticed we have, there was an exhibit attached to Mr. Darnell's testimony that identified the members of the PNMR board, but it hasn't been clear to me. Maybe it's in the record someplace, I don't know. But I'd like to know which of those board members are independent or not under the New York Stock Exchange rules. If it's already in the record, I'd appreciate for PNM letting me know. Otherwise, I'd like to get just a brief statement or two from a PNM witness about that. Mr.
Your Honor,
Alvidrez?
Yes,
go ahead.
yes, thank you, Your Honor. It may be in the record, but we have a voluminous record, and sitting here right now, I cannot tell you for certainty where to find it. But if it's all right with you, over the lunch hour, we will confirm whether it's in the record, and if not, arrange to have someone. Do you want us to make a verified filing, rather than call somebody back, or what is your preference?
Well, my preference is whatever is most convenient. I mean, I think if you could check through the record this morning and, let me know over lunch, after lunch, if it is in the record, that would be fine. If not, it would probably be simplest if you could just find somebody, probably maybe Mr. Darnell or Mr. Terry, who could just briefly come on this afternoon and identify those identify the people on the board who are independent.
I of course, I'm not able to access their schedules right now, so I'm not sure what their availability may be, but we will get you the information today.
Okay, well, we can work out something that's acceptable.
Okay, thank you.
Okay.
Mr. Schonauer, this is Peter Gould for NM area. I know that there is a link on PNM's website that has the biographies and the current biographies of all of the PNMR board members. And I don't know, perhaps just providing that link might be the easiest way to do it.
Well, I'm not sure that will indicate whether they're independent or not under the rules of the New York Stock Exchange.
They have full bios, and I think the information might be in there in terms of whether or not they're employed by PNM or have a familial relationship with PNM. But anyway, just a suggestion. Thank you.
Okay.
Mr. Herring-Zimmer,
Yes, Mr.
and
O'Brien.
I assume that will take the form of some kind of just administrative notice or something made available to all of the parties in the proceeding.
We'll have to see what PNM has in terms of information on that, whether it's already in the record, whether they can find, whether someone's available to testify about that. I think that's something we'll determine after lunch today.
Yes, sir. All right, thank you.
But of course, it will be made available to all the parties. Okay, is there anything else to Mr. Sandberg? Okay, will you call your witness?
Good morning, everyone. Good morning, Mr. Sandberg.
Good morning.
Mr. Lee, would you ask the witness, Mr. Sandberg, to affirm his testimony this morning?
Would you raise your right hand? You solemnly swear affirm the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
I do affirm.
Thank you, sir.
Good morning, Mr. Sandberg. For the record, my name is Marielle Nanasi. I am the Executive Director and Attorney for New Energy Economy. We have uploaded a number of exhibits that are, I believe, your testimony, and I'd like to go through them. Could you go to New Energy Economy Exhibit 52, please? Is that your direct testimony and exhibits of April 2nd, 2021?
Give me 1 second. I have the Dropbox list in front of me. Yes, Exhibit 52 is the April 14th direct testimony, correct?
And sir, is Exhibit 53 your rebuttal testimony and exhibits of April 21, 2021?
Yes, 53 is the second round.
And is Exhibit 54 the testimony and exhibits of Christopher Sandberg in opposition to proposed transaction and second amended stipulation of July 16th, 2021?
Yes, it is.
And sir, is Exhibit 55 your rebuttal testimony and exhibits of July 29th?
Yes.
And if I were to ask you those questions today, would your answers be the same?
Yes, they would.
And do you affirm that they are true and correct to the best of your knowledge?
I do.
Hearing examiner Schnauer, I'd move the exhibits 52, 53, 54, and 55 into the record. New Energy Economy exhibits.
Your Honor, this is Rick Alvidrez.
Yes, go ahead.
And we have an objection to any Exhibit 54 as it is non-compliant with your August 6th order requiring NE to strike certain portions of that order, of that testimony. And specifically, NE did not strike pages 3 through 17 of Exhibit CKS1, that is the affidavit of Mr. Berry. There were only pages 1 and 2 permitted and a few lines from page 18. And yet it appears the entire Berry affidavit is among the documents that were included with Exhibit 54. Likewise, the hearing examiner struck Exhibit CKS3, and CKS3 is included within the documents that were uploaded and are, as we understand, are being presented today. So we object on the grounds that this exhibit does not comply with your order.
Are those the only objections that you have? I know that I struck portions of Exhibit 53 as well, the Sandberg rebuttal, and I struck exhibits from the July 29 testimony.
Yeah, Exhibit 53, it's very difficult to track because what apparently NE does is reformats the testimony. It's not like they're strike-throughs in many instances. As best we can tell, any Exhibit 53 is has reflected what you struck. Any Exhibit 55, as best we can tell, is also appears to comply as best we can tell. But again, it's very difficult because the exhibits have been renumbered, and it's just extremely difficult to track and confirm that there are no other changes because of the way that NE has handled its exhibits.
Ms. Nanasi, can you address this?
Yes, I think that it is true that CKS 1 and 3 should not be included in Exhibit 54, and we agree with that. I do believe that there was, unless I have other specifics, I don't know why. Anyway, I'm sorry, and I will have this pages 3 through 17, I believe, on CKS 1 eliminated. I apologize. And CKS 3 should be eliminated as well.
What about Exhibit 53, the April 21 rebuttal from Mr. Sandberg?
Exhibit 53. What was the problem there?
Well, I issued an order in response to a motion to strike of the joint applicants, striking certain portions of that rebuttal testimony. And I have not been able to confirm, actually, I don't know whether that has been eliminated from the testimony that you're offering as Exhibit 53.
I believe it is.
Okay. And Mr. You're okay with that?
Your Honor, again, the best we can tell, it's been altered, but it looks as though Exhibit CKS 66 was stricken as required. The one that we have, a little still remaining question about is NEE 55 because of the renumbering. And the changes aren't done in strike through or whatever. They just take out and submit the testimony as if it never existed. So it's hard to track. It's a new document, if you will, from the original filing.
Okay.
So they even added line numbers which were not included on the original filing of NEE 55.
Well, let's narrow this down. It appears that there's no objection to Exhibit 52.
That's correct.
And there's no objection to NEE Exhibit 53.
That's correct.
Okay, and the objection to NEE 54 is that there are two exhibits that have not been stricken from that, CKS1 and CKS3. Is that right?
That's correct, Your Honor.
And that there are certain portions of Mr. Sandberg's testimony that have not been stricken. Is that right?
I believe that's correct as well, the references to those exhibits.
Okay.
I don't think that is correct. I think that I deleted what you ordered, and I don't know why this 3 through 7, page 3 through 17 of CKS1 and CKS3 should not be there, and that I am prepared to upload a new version before the end of his testimony.
Okay. Then in terms of Exhibit 55, what is the issue with that? Have the three exhibits that I struck, have they been eliminated from the testimony?
Yes.
Those exhibits, I'm sorry. Those exhibits appear to be removed. The difficulty, Your Honor, is we just can't tell, without going word by word to see if there's any other changes. I mean, this is not a situation where NE has, taken its original filing and then struck through so we can all track what has been removed. As I said, they've added line numbers, which is appreciated on some levels, and then removed some of the exhibits and then renumbered them. But it appears that the exhibits 3 through 5 are no longer included. It's just that you can't track from what was originally filed to what was uploaded. So that's our difficulty with NE 55.
Do you have as to what we should do?
Well, I think requiring NE to correctly submit these exhibits is the appropriate remedy. That is, the exhibits as originally filed with, the strike-throughs clearly shown, so that everyone can verify that, those are the only changes that were made.
How do we cross-examination this morning if we're waiting for that to happen?
Hearing examination hour, is that what your preferred method is? Because that's not what I believed. I thought we should just remove the documents and any references to them as per your order. And that's what I did on Exhibit 55 and the others. Except for CKS1, I agreed that that was an oversight, and I don't know why that was uploaded that way, but that will be changed. But otherwise, I removed all that reference, and I didn't know that there was some rule or there was no instruction in your order that that's how you wanted it to be, either strike outs or redactions, or I just removed it.
Okay, well, I did not the reconfiguration of your exhibits, of your testimonies. I ordered that certain pages be stricken, and the usual way that is accomplished is by strike-throughs or blackouts, and that is the appropriate way to do it. So I think that the best way to handle this, I mean, everyone has a copy of the originally filed testimonies of July 16 and July 29. For the purpose of this cross-examination, I'd ask that everyone refer to those original pages and the original filing, and that we follow up later with the strike-throughs that are necessary to accomplish what I required in my order.
Do you want me to resubmit all of the testimony and do it that way?
Well, I think there's no objection to NEE exhibits 52 and 53. I think the confusion lies with exhibits 54 and 55. So I'm prepared to admit exhibits 52 and 53 as they are shown at Dropbox. But in terms of 54 and 55, I'm going to ask that you strike through versions of those documents and strike through and black out the sections that I've stricken. And when you've accomplished that, you can upload them to Dropbox. You can let all the parties know, and we'll address again whether that's been done adequately. And then at that time, I will admit that those two exhibits into the record when I'm satisfied that you've done the strike-throughs and or blackouts that are needed to accomplish what I ordered in terms of striking testimony.
Your Honor, Rick Alvidrez, I actually don't have the original filings. I mean, these are quite voluminous. And so what I brought over is what was downloaded by NEE. So my examination, when I refer to page number and pages and line number, are going to be to what was downloaded and not what was originally filed.
I'm really sorry. I just want to say I'm really sorry. I didn't know that there was no direction in the order, and I'm sorry that you say that this is appropriate. I thought remove would be what you wanted. And the reason is because I didn't think you wanted it to be in the record, which is why I did it the way I did it. So there was a reason that I pursued it that way. But the only thing I think that really we're talking about is page 3 to 17 of Exhibit 1 and CKS 3, which we can black out in minutes and upload that. There is no objection to 55, and I believe that it complies with your order. And so I'd ask that we use the documents that are there, and we will just have that in minutes. Exhibit 54, just take out, we'll black out pages 3 to 17 and black out CKS 3.
And we do object to 55 as being altered, Your Honor.
In what way was it?
Well, it's had exhibits renumbered. It has page numbers that have been added. And so it is not, we can't really see what has been changed because we don't have the original with strike-throughs.
But that's
I don't know whether it's been changed or not.
That's what you're prepared to do your cross-examination on, you're telling me.
I'm using what was downloaded as the basis for my cross-examination, Your Honor.
Okay. Okay, well, hold on a second. I'm going to admit right now, I'm admitting NEE exhibits 52 and 53. So as presented in Dropbox. And I'm going to be deferring a ruling on NEE exhibit 54 and NEE exhibit 55 until I have a chance to review those documents to see if they have achieved what I ordered to be achieved in my orders striking striking portions of that testimony. And Mr. Alvidrez, you're going to conduct your cross-examination of the documents that you have, which are the documents that are currently in uploaded to Dropbox. And Ms. Nanazi is going to today strike out or black out anything additional that needs to be stricken or blacked out to conform to my orders. And that will be then the version that gets admitted into evidence. Is that clear to everyone?
Yes, Your Honor.
Thank you. Can I upload the exhibit 54 with page 3 to 17 of CKS 1 and 3 blacked out right now and make that a revised exhibit 54?
Can you do strike through?
Sure.
Do that. And then black out the attached exhibits.
I think that the testimony is correct. It's just the exhibits.
Okay, well,
Can we black out the exhibits?
just black out the exhibits.
Thank you so much.
Okay, so let's move on with cross-examination. The Water Authority has reserved 10 minutes. Mr. Harris.
The Water Authority waives our cross.
The Bernalillo County, Mr. Albright, you reserved 15 minutes.
Yes, Mr. Hearing Examiner, I have. Good morning, Mr. Sandberg.
Morning.
I'm Jeff Albright with J. Albright Law LLC, and I represent Bernalillo County in this proceeding. I will primarily be focusing my attention. I'm sorry, did someone say something? Okay, I'm primarily going to be focusing my attention on your April 21 2021 rebuttal testimony. That's currently NEE Exhibit 53. And also I have some questions on 54. I believe I'll just be referring to the testimony and not any reference to the exhibits that are in question or being modified on that. And I may skip around just a little bit, given that my time is limited. Have you, I don't think I have cross-examined you before in any proceeding. Is that correct, Mr. Sandberg?
I'm quite certain you have not.
Okay. I do have a tendency from time to time to ask compound questions. I'll try not to do that, but if I do need to restate a question, please let me know, and I'll try to do my best to keep it simple and organized for the record. I would like you to turn to what I have from on Exhibit 53, your rebuttal testimony and exhibits, to page 29. And I don't know if page numbers have changed or not. I've gone by the original filings here.
And to be clear, what I have in front of me are the Dropbox versions as well. So I'm sorry, what page did you want to go to?
Okay, specifically, I'm looking at on the bottom. It's the bottom page 29. It's page 28 has some discussion with regard to independent evaluator, and that begins. You start with an answer that says at lines 4 through 7, a clarification independent evaluator, which I recommended in my direct testimony.
I'm sorry.
Can you
I
find
apologize, but no, I'm not getting at high enough page numbers. Are you in the April 21st testimony?
Yes, April 21st, rebuttal testimony and exhibits of Christopher K. Sandberg.
All right. The version of Exhibit 53 that I have in front of me runs out on page 22.
All right. Let me read the question and the
Yeah,
answer.
that's fine.
And I
Yeah.
think that may be the quickest way to resolve this. And then I'll just ask my question. So the
Agreed.
question is, what then are you recommending? Answer, a clarification. The independent evaluator, which I recommended in my direct testimony, page 39 to 41, and which was emphasized in the testimony of Larry Blank for the city of Albuquerque, should be employed not just for acquisition of generation, but for all decisions under implementation of the long-term transmission plan. Does that sound familiar?
Yes, sir.
Okay, so my question is that Bernalillo County proposed an alternative through the testimony of Ms. Reno, and that was that PNM, the PNM would provide a list of potential independent evaluators, and that the commission would be able to choose from that list for those RFPs or for those that required evaluation. If there were either affiliated parties or Avangrid holding companies or some kind of parties that involved Avangrid or PNM involved in the RFP. Do you recall that from Ms. Reno's testimony?
I do.
So why wouldn't that be an acceptable alternative?
Well, it certainly would be an improvement to having PNM or in some fashion actually directly pick the evaluator. However, it does still provide an extraordinary degree of control to PNM in that it would make up the list. And if the commission were to be limited to only picking someone from that list, we're really not very far advanced from PNM doing that itself. I think it is at best a small improvement. And I think the better approach remains having the commission do the selection of the independent evaluator without interference from PNM.
But isn't it likely in that kind of a situation that the independent evaluators are likely to come from the same subset that PNM might choose?
I have no way of knowing what the commission would decide to do for its selection criteria, but I think it is likely that it would be different than PNM's selection criteria because the commission would have no reason to prefer persons that would be likely to prefer a PNM affiliate, whereas PNM clearly has that interest.
Okay, again, I may jump around a little bit just for the sake of time and the question. So I would like to turn to the testimony in opposition, and this is the July 16, 2021 testimony.
I am on July 16th.
Okay, and again, the page numbers may differ. I'm going by the original filing. So I'd
Understood.
like you, if you can, to turn to the sections that discuss rate freeze. On mine, it begins on page 43 and 44.
I am scrolling as I speak.
I believe it's on page 40.
Yeah, I think I scrolled past it. Sorry. I have issue number 6, a rate freeze is required as the heading. Is that what you're looking at, sir?
There is that heading with regard to
Okay.
rate freeze, and then you
Okay.
have a discussion on a couple of the subsequent pages.
Yes, sir.
Okay, so here again, are you aware that in Ms. Reno's testimony, she had proposed the filing of a rate freeze no later than June of 2022?
Yes, sir, I am.
And with that, if the filing takes place under the statutory requirements of a 9-month period, if you use a future test year, can be expanded to 12 months, wouldn't that provide rate relief that would normally be accompanied by a rate freeze?
For that period of time, yes.
And so would you support that that recommendation from Ms. Reno?
I think it is helpful. My understanding from looking at some of the earlier merger cases is that rate freezes have been implemented for a longer period of time than she is recommending. And I certainly would say that it is in ratepayers' best interest for the freeze to extend longer rather than shorter. So I appreciate her suggestion, but I think it is still rather short.
Do you know when PNM last had a rate proceeding and that was approved by the commission as far as a rate increase is concerned?
I'm trying to remember. This was an item of discussion in the decoupling case. It's been at least 4 years is my recollection.
So it has been a while since PNM has had a rate case with changes in rates for the customers, correct?
It is true that it has been a decent period of time since there has been a change in rates. Rate freeze is a bit of a term of art. I will simply note that rate cases can result in rates going up and rates going down.
You also, and I may be able to find it, but just as a general question, you had questions as well, or some concerns with regard to the arrearages and the reimbursement on arrearages being insufficient. Do you remember that testimony?
I do, sir.
And isn't it true that a lot of the arrearages occur in the normal course of events with or without COVID?
I do not know the specifics as to PNM's historical experience. I would agree as a general matter that most utilities experience some arrearages from some of their customers, but I don't know the baseline to which you are suggesting we should look.
Well, and without that baseline, isn't identifying a dollar amount to address arrearages somewhat problematic?
I understand the question you're posing, but I think the best policy decision at this point, given the tremendous overlay resulting from the last 18 plus months of COVID restrictions and COVID effects, is to realize that this is a unique circumstance that is fundamentally different than the ordinary course of business for PNM's customers, and to treat the arrearages that are present now as a special event and deal with them as a whole.
Mr. Hearing Examiner, how much time do I have left?
2 minutes.
All right, let me ask a final question or a couple of questions related to the rate relief. You're aware that the $50 million that Bernalillo County has proposed an increase to 65, and I believe there's been testimony as well that the Water Utility Authority has suggested that an additional $2 million be added on to the rate relief. I believe Mr. Blaska has included that in his testimony. Are you aware of that, or do you recall that?
I believe I am aware of those. I'm not sure that I followed all of Mr. Blaska's testimony as well as one can on a modest connection, but I believe the number has gone up. Yes, how's that?
Okay. Do you have any objection with regard to the proposed rate increases by Bernalillo County and the Water Utility Authority?
With all due respect, I believe they remain insufficient.
And what do you base that on?
There is no, how shall I put this? I'm not aware of any reasoned basis for the number that the joint applicants have now agreed to, somewhere in the mid or upper 60s. It does not appear to have been based on any actual measurement or fundamental idea. It simply appears to simply be a number that has been offered to induce other parties to join a settlement.
Okay, Mr. Hearing Examiner, that's all the questions I have for Mr. Sandberg. Mr. Sandberg, thank you very much for your answers and for dealing with my difficulties in getting around the documents as well. But I appreciate your responses and thank you for your time.
You're very welcome.
Okay, NM area waived its cross. The next party then with cross is WRA. Ms. Beatles, you reserved 30 minutes.
Yes, I don't have that much cross. However, I should alert you and the others that we're having technical difficulties in the office. So I am on Zoom using my cell phone. And fortunately, I had on my laptop 2 pieces of testimony of Mr. Sandberg's that I intended to ask questions on already open. So I think I can go ahead and ask the questions that I had planned to, but it will be much less than I had planned, and parties will probably appreciate that. So good morning, Mr. Sandberg.
Good morning.
So let me refer first to I believe it is page 2 of what has been marked, although not yet admitted, Exhibit 55, which is your rebuttal testimony and exhibits in opposition to the transaction and stipulation.
Dated July 29. Or is this is, I guess this is one you don't have on your cell phone. I believe we are on the same document.
Okay, thank you for understanding. And so on page 2, you first state your quote, deep concerns regarding the apparent behind the scenes negotiations. Do you see that?
I do, ma'am.
Sir, have you ever participated in negotiations at the PRC in a case that's complex and numerous issues?
If your question is, as I think it is, regarding participation in a matter before this New Mexico PRC as the commission, then the answer is no. If your question is more general, yes, I have, but in other places.
Okay, thank you. That does answer my question. So you don't know whether it's common in big PRC cases for the company to meet separately with one or a few parties at a time.
I do not know. I believe there had been a direction from the commission in this case for all parties to be involved, but I don't know how that squares with historical.
Mm-hmm. And I'm going to now go to a different piece of testimony. Let me open it. This is what has been marked not yet admitted as Exhibit 54, testimony in opposition to the proposed transaction and stipulation. And I have a couple of questions about your testimony about maintaining or claiming that Iberdrola is not a green leader. And that testimony starts on page 69. And my questions start with your testimony on page 71, starting on line 3 of page 71. And let me know when you're there.
I believe I am.
Okay, thank you. And I'm going to ask you to clarify your math for me. If my math skills serve, I believe this means that Iberdrola / Avangrid have current investments as follows. And you include 8,560 megawatts of wind. And however, that number is the figure that you say earlier that you got from Senor Blasquez about Avangrid Renewables and Avangrid Networks, which is their domestic wind. So I'm not sure why you use that figure, because you're coming up with global numbers and you don't appear to use their global number for wind.
I'm sorry, what was the question?
Well, is that true that you are on page 71, lines 3 through 5, estimating the relative composition of renewable resources in their global investment portfolio, but you're using the wind number that reflects only their holdings in the US?
I was attempting to use the numbers provided by Iberdrola and Avangrid. If they had, well, but that's the answer, is my numbers were based on my understanding of their responses.
Mhm. And you quote from their response on page 69, line 23 through 24, where it states that Avangrid Renewables owns or co-owns approximately 8,560 megawatts of wind, solar, and cogen. Do you see that?
I do.
Megawatts of wind, solar, and
Cogen, C-O-G-E-N.
thank you.
And that 8,560 number is the same that you used to show relative composition of their total holdings on page 71, right?
I think I believe I said at line 3 of page 71, that means that, I'm going to quote myself, this means that Iberdrola / Avangrid have current investments and etc. So I was attempting to use the data regarding Iberdrola and Avangrid. And it was their numbers.
Thank you. So did you do any independent research of your own to verify how much wind, solar, and other renewable that Iberdrola has globally?
I'm trying to remember the level of detail that Iberdrola may have had in some of their essentially annual reports. It's not the term of art they use. My recollection is that I did look at Iberdrola and their essentially reports to stockholders. But at this point, I don't recall what level of detail there may have been in those. I just don't remember.
Would it surprise you to learn that S&P Global reports Iberdrola SA's total renewable holdings for 2020 as 17,863 megawatts, with approximately 1,700 under construction and another 15,600 planned?
I would have no way of agreeing or disagreeing with that. I don't know the source, I'm sorry.
All right, I have no further questions. Thank you all.
You're welcome.
Hey, General, you've reserved 30 minutes.
Sorry, Judge, you dropped out.
The Attorney General has reserved 30 minutes.
Yes, Mr. Hearing Examiner, we waive cross at this time. Thank you.
Who was that?
Gideon Elliott for the Attorney General.
Okay. IBEW reserved 5 minutes.
Thank you, Mr. Hearing Examiner. Good morning, Mr. Sandberg. My name is Justin Lesky. I'm the attorney for IBEW Local 611. That's the International Brotherhood of Electrical Workers.
Morning.
I want to ask you some questions related to what has been marked as NEE Exhibit 54, which has been marked that way, not admitted yet, but from what I understand, the page numbers haven't changed.
Let's hope.
So hopefully we can get on the same page with that. And what I'm looking at relates to the 20 electrical craftsman positions and your testimony about that.
I recall that generally, sir. I'll be glad to look with you for the proper page, but I do know that I testified on that topic.
Right. I'm looking at page 54 of that exhibit of your testimony. So, and it's lines 9 through 12.
Yeah, I'm scrolling. Okay, I'm in the section about jobs.
Okay, so hopefully we're on the same page here.
We're close.
But what you testify there is that for 87% of the 150 jobs, Avangrid and Iberdrola can immediately create them without the merger, since those 120 jobs will be outside PNM. And then you say, for the other 20 jobs, since it seems likely they will actually be just displaced San Juan employees moved elsewhere inside PNM, PNM can create those jobs without being absorbed into Iberdrola. Is that your testimony?
Yes, sir.
Okay. What I'm wondering is, what is the basis of your belief here that it seems likely that these jobs will actually just be displaced San Juan employees? What's the basis for that statement?
The stated commitment by joint applicants, or perhaps more particularly by PNM, that first, what's the word I want? First consideration or first preference for those jobs will be given to displaced San Juan current employees. I'm taking them at their word.
Okay. Do you know if the displaced San Juan employees are actually trained to perform those electrical craftsman positions?
I don't know what the jobs that they currently hold are to that level of detail, and joint applicants have not provided any sort of detail as to the jobs they're talking about creating internally in PNM. So I think it is impossible to know the answer.
Okay, so you don't actually know whether these 20 electrical craftsman positions will actually be filled by displaced San Juan employees, isn't that correct?
I don't believe anyone knows at this point.
Okay. The other issue I wanted to ask you about relates to page 56.
Okay, I'm going.
I'm sorry. Before I get there, though, let me ask you one more question about the 20 jobs. Do you know whether or not without this agreement and stipulation, those 20 jobs, those 20 additional electrical craftsman positions will exist? Is there some other agreement where PNM has said, oh, we're going to create these 20 electrical craftsman positions anyway, even without the stipulation?
I think PNM has been totally silent on the reason for, as well as the nature of, those supposed 20 new jobs. So I think it is, again, impossible to know what PNM might be planning. It's only the very vague statements that we've received so far from witnesses that there are some kind of jobs that are not presently being done within the utility that suddenly now need to be done.
Okay, but we only know for sure that the 20 electrical craftsman positions will be created as a result of this stipulated agreement, correct?
I would have to disagree with that, sir. We know what will happen, they say, if the merger is approved and goes forward. We have no idea what will happen if it don't. If it does not go forward, we don't have that information.
Okay, fair enough. And then I'm looking at page 56 of your testimony, lines 4 through 7. So let me know when you're there.
We're not gonna sync up on page numbers, I suspect, all day today. So please tell me what the question is, and I'll find it that way.
Okay, your testimony is the rate effects of labor relations and employee wage benefit levels are standard issues in utility rate making. And I assume that not breaching a negotiated and effective collective bargaining agreement is something PNM would normally do. Was that your testimony that you recall?
Yes, sir.
Okay. Are you familiar with the second amended stipulation, which is, I think, joint applicants exhibit 4?
I have read it.
Okay. Do you recall a provision in there that states that joint applicants will commit that there will be no involuntary terminations except for cause or performance, with the exception of San Juan, and no reductions of wages or benefits to union or non-union employees for a minimum of 3 years. Do you recall that provision?
Yes, sir.
Are you aware of any agreement PNM has made outside of this stipulation where they've made that same agreement? No reductions in jobs, no reductions in wages, no reductions in benefits. We're not going to do it for 3 years anyway.
Not having had access to the existing collective bargaining agreement between IBEW and PNM, I do not know.
Okay, that's all the questions I have, Mr. Hearing Examiner.
Thank you. Mr. Haverly, you're up next. You reserved 90 minutes.
Thank you, Mr. Hearing Examiner.
And then, Mr. Haverly, as you're conducting your cross, keep in mind that we want to take a break around 10:45. That's about halfway through your 90 minutes. So just to give you a heads up.
Understood. Thank you, Mr. Hearing Examiner. Good morning, Mr. Sandberg. My name is Brian Haverly. I represent Avangrid and Iberdrola.
Good morning.
Mr. Sandberg, you are a lawyer by education and training. Is that correct?
Yes, sir.
Okay. And you practice law in Minnesota. Is that correct?
I was admitted to practice in Minnesota as well as a number of courts, federal courts of appeal, but I have worked in, done work in other physical states during that same time period.
Did you hold bar licensures in any other states, Mr. Sandberg?
No, sir. No, sir, I have not.
Okay. And Mr. Sandberg, you are not currently authorized to practice law in Minnesota. Is that correct?
That is correct.
And you are not licensed to practice law in New Mexico currently. Is that correct?
Not only currently, I never have been.
Mr. Sandberg, you've never appeared as an expert witness in an electric utility merger case. Is that correct?
Yes.
Mr. Sandberg, have you ever had an academic paper published on the subject matter of electric utility mergers?
No.
Mr. Sandberg, I do have the Dropbox documents, so that's what I'm going to use to ask you questions. I understand that that's what you're using as well. Is that right?
I believe I am.
Okay, so I'm going to give you the page numbers and sites that I have, and we can start talking from that. And I hope we sync up.
We'll do our best.
Okay, so I would like you to go to your direct testimony, April 2nd. I believe that's Exhibit 53, page 7.
Mr. Shannara, 53 is the rebuttal testimony of 421. If it's the direct testimony, it's Exhibit 52.
You're right, Mariel. I apologize. That is 52.
I'm Ms. Nassi to you.
I apologize for that, Ms. Nassi.
Let me shift over. And you want page 7? Do I remember correctly?
Yes, sir. Thank you.
Yep. Okay, give me a sec. Okay, that page contains the heading executive summary.
Yes, I believe that is accurate. So, Mr. Sandberg, going down to the bottom of that page and then continuing on to the next page, you state that one of the reasons you oppose the merger between PNM Resources and Avangrid is that, and I want to quote this, PNM goes from being a significant New Mexico business responsible to the local community to an insignificant footnote on a multinational conglomerate's balance sheet. PNM will be responsive to its new masters, not to any local community or authority. Is that an accurate statement of what your testimony says?
That is what the testimony says.
Okay. Are you aware, Mr. Sandberg, that PNM's current board of directors are comprised solely of PNM employees?
My recollection is, to the contrary, that the listing of board members has non-employee board members listed. There's an exhibit on this testimony that was just a download from the company's website about its board. So I'm sorry, that's my recollection.
And Mr. Sandberg, just to clarify, there are two entities that are involved in the New Mexico side of the what we'll call the PNM entities, and that is PNMR or PNM Resources Inc., which is the holding company, and then there's Public Service Company of New Mexico, which is the utility. Do you understand that there are two different entities?
I understand that PNM is one of the two wholly owned subs of PNMR.
Okay. So when you were talking about the independent or the board of directors just a second ago, were you talking about PNM, the utility, or were you talking about PNM Resources, the holding company?
I'm looking to see how that was presented on the website. Given the nature of your question, I'm going to assume that what's on the website is actually the PNMR board. But that is, grab me a second here. Yeah, I'm sorry, I'd have to go find that exhibit. I inferred from the website materials. Well, I'm sorry, I'm gonna stop. I'll stop my answer and say I don't know at this point what PNM's board is, to the extent it is different than those in the PNMR board.
Okay. So, Mr. Sandberg, you're not aware of whether the PNM board has any independent directors on it currently. Is that correct?
I do not know.
Would you agree with me as a basic tenet of corporate law that PNM's board of directors owe a duty to their shareholder?
I think that's not really consistent with what I at least have seen in New Mexico's corporate statute. And I don't know that I have the cite to the statute at my fingertips. Actually, I do. 53-1135. I'm sorry, Mr. Lee. 53-11-35 parens capital B close parens. What I found there was that directors have a good faith obligation to do things that they believe to be in the quote best interest of the corporation, unquote.
Okay, is there anything else in that statute that discusses duties that are owed to shareholders?
I do not know. I found that to be the most relevant piece.
Okay. Well, let's talk about PNM Resources. PNM Resources, Inc. is a publicly traded company, correct?
At present, I believe that is true.
Okay. And PNM Resources current board of directors owe a duty to shareholders. Is that correct?
I would have the same answer as I did a minute ago. I think that New Mexico law imposes a duty to act in the best interest of the corporation.
And in acting in the best interest of the corporation, does that include shareholders?
May or may not.
Mr. Sandberg, are you aware that the four largest shareholders of PNM Resources are investment funds?
I do not know.
In the stipulation, the second amended stipulation, Mr. Sandberg, are you aware that that the joint applicants are agreeing to include independent directors on the board of PNM, the utility company?
I believe that is contemplated. Well, I'm slightly hesitant in answering your question as posed because of the ongoing changes that are being made to the second amended stipulation. but I believe that is still true, yes.
Are you aware that the joint applicants have agreed that the independent directors will have control over declaring dividends?
I believe that is also true, yes.
So if the independent directors were concerned about the financial status of PNM, they would be able to control the amount of the dividend issued to the shareholders. Is that correct?
That would be, I believe, among the things that they could do.
And they could even potentially not issue a dividend. Isn't that correct, Mr. Sandberg?
If they have that majority vote control, then that would be, if they believe that not issuing a dividend would be in the best interest of PNM, then yes, I believe they could do so.
Are you aware that the independent directors will also be responsible for setting compensation at PNM for the executives and the board members?
I believe that is also true and consistent with NYSE provisions regarding independent directors.
Mr. Sandberg, the NYSE guidelines don't apply to PNM, the utility company, though. Isn't that correct?
If the basis for your question is that it's a controlled entity, then the answer would be yes.
And the fact that it's not a listed entity either. Is that correct?
Fair enough.
Mr. Sandberg, do you still believe that a majority independent board on the PNM board of directors is an appropriate obligation in this case?
I'm sorry, I was not sure I heard. Could you restate the question, please? I may have missed part of it in the electronics.
I can, and it probably was a poorly worded question, so don't worry.
But even better then.
Mr. Sandberg, are you advocating for a majority independent board at the board of directors for PNM?
I am, but not necessarily as an exclusive. The problem is the word majority. There is a difference between a majority and a board that is completely independent directors. While a majority board sounds like a good idea and maybe a sufficient idea because the majority would be, obviously have the majority of votes. The difficulty, I think, remains that those non-independent directors who are present and active participants in the board have an opportunity to directly influence, guide, suggest, cajole the things that take place around a board table to direct their non-independent influence on the independent directors. That is what troubles me about a simple majority being independent versus the board being independent.
So are you advocating that the entire board of directors for PNM be independent?
I think that would be the preferred outcome. Certainly a majority independent would be better than non-majority independent. But given my preference, yes, I think that a board of independent directors would be appropriate.
Mr. Sandberg, do you believe that independent board members would owe some special duty to customers?
I don't know what you mean by special duty.
Well, that's fair. What I'm trying to understand is you said that, and I don't want to get this wrong, and so please correct me, that you would prefer a completely independent board over a just majority board. Is that correct?
It is.
Okay, and that's because you would like to not see any influence of the company at the board of directors. Is that right?
That is correct, but perhaps understated. There are individuals who could be non-independent directors who don't have to be employees of the company.
Okay. You're aware that the joint applicants are agreeing in the stipulation to make the board of directors 100% New Mexico residents if this merger is approved at PNM?
I believe that is the current state of their agreement, yes.
Okay. So, Mr. Sandberg, if you have a group of independent directors that are all New Mexico residents, does that allay some of your concerns?
I'm not so, I'm not necessarily an advocate for only New Mexico residents. I understand from various witnesses' testimony the concern that going to wholly independent board might make it more difficult to find knowledgeable individuals who are in fact independent to serve, to the extent that limiting board members to New Mexico residents would limit the pool of qualified independent directors. I can see a disadvantage to limiting directors to New Mexico residents. I see the advantage of New Mexico residents being familiar with local issues and being more connected to the service territory that PNM serves. And I think that is a good thing. But I recognize that it may well limit the pool of qualified candidates. Those are slightly contesting goals.
Mr. Sandberg, would you ask the commission, or would you ask the commission in your testimony today? Strike that. Actually, I don't know where I was going to go with that question. So, Mr. Sandberg, you would like to have a board of directors that does reflect New Mexico, or that has the ability to take into account New Mexico residents' concerns. Is that right?
I would state that slightly differently. I would like the board to be cognizant of the interests and needs of the New Mexico community.
Mr. Sandberg, does it cost money to have independent directors on a board of directors?
As opposed to what?
Well, is it customary for members of a board of directors to be compensated for their time serving on a board?
I believe it is.
And is it customary that if the members of the board of directors are employees of the company, that there is no additional compensation?
I don't know that I could say there's a general principle at work there. I don't know that that's the case.
Do you know how much the average compensation is for independent members of a board of directors for utility companies are in the United States?
No, I do not.
So you don't know what it would cost to attract qualified individuals either within New Mexico or outside of New Mexico to sit on the board of directors at PNM?
That's kind of a different question than your preceding question. I don't know that attracting board members to PNM is the same as attracting board members to other utilities elsewhere in the country. I understand your question in terms of, will it cost something to get independent board members to serve? I assume it will.
But you don't know how much that might be. Is that correct?
I'm trying to think if I have seen any current numbers. I do not.
Okay. So there's no guidance you can give the commission in evaluating whether a full board of independent directors would be worth the cost to ratepayers. Is that correct?
Given the $1 billion a year that PNM bills, I think it's very hard to imagine a compensation in total to a board that would be more than rounding error on cost to consumers.
So the commission doesn't need to be concerned about costs if it's just going to end up as a rounding error in rates. Is that what you're stating, Mr. Sandberg?
I do not know exactly how detailed this commission reviews costs of service when it does a general rate case for PNM or other utilities. It is my experience that at the very least, commission staff and public advocates will burn down quite a long ways into the costs related to a utility's request for rates. I do not say, and it is not my testimony, that the commission should ignore what board members may be paid, but it would be one of a great number of cost items that would be considered in a rate case. And at some point, it is my experience, commission staff and public advocates realize that fighting over tenths of a cent is less important than fighting over major items.
Mr. Sandberg, do you believe that the New Mexico Public Regulation Commission is currently able to effectively regulate PNM?
I know of no reason why it is not.
And you believe, or let me ask you this, do you have any reason to believe that the commission is not able to regulate the other utilities that are operating in New Mexico?
I have to preface my answer with this. I've been in New Mexico for 4 years. I have not devoted time in much of that period to looking at the PRC or its activities. It really has been in the last year to 18 months that I have done so. I am aware of the major political, I'm going to use the word upheaval, but that's probably a little strong, conundrum about whether the commission should be elected or appointed and the changes that are underway there. Those kinds of concerns, in my experience elsewhere, often arise when there is a belief that the commission as constituted isn't doing a good job. And to be precise, I went through a period where Minnesota's commissioners went from being elected to appointed. So I have some reason for saying that previous statement. So I'm reluctant to offer an opinion because at the very least, the change in constitution of the commission does suggest to me that at least there was a political belief that the current commission may not have been operating and regulating in the best possible way.
Mr. Sandberg, the main regulatory authority is able to effectively regulate Central Maine Power. Is that correct?
I have no idea.
Okay, do you have any idea if the Connecticut Regulatory Authority is able to effectively regulate United Illuminating?
I do not recall having any experience with Connecticut.
Okay. And are you aware whether the New York regulatory authorities are able to adequately and efficiently regulate New York state electric and gas?
The only connection I can think of in New York may have been on a telecommunications matter, so I have no basis for an opinion about gas and electric.
I'd like to take you to your July 16th testimony. Mr. Sandberg, could you please bring that up?
I will attempt to do so. I have the July 16th, yes.
Can you go to page 14, please?
I will scroll down. Okay,
Okay, starting at lines 18 and going on down, you indicate that you have concern that Iberdrola and Avangrid affiliates will generate energy that PNM pumps across state lines to consumers elsewhere in the Southwest and West. Unless there are meaningful, stringently enforced safeguards in place, those affiliates will have the opportunity to get preferential treatment for interconnection, power and energy purchases, wheeling, and ancillary services.
I'm sorry, after power and energy purchases,
Wheeling, WHEELING, and ancillary, I can't pronounce, sorry, ANCILLARY services. Sorry. Is that an accurate statement of what your testimony says?
you have read the testimony accurately.
Okay. Mr. Sandberg, are you aware that the FERC scrutinizes and regulates affiliate transactions relating to power purchase agreements?
I'm generally aware of the FERC's regulation at the wholesale level. Yes.
Okay. And are you aware that the FERC also regulates interconnections and transmission between affiliates?
I believe that is generally true.
Do you believe that there is any reason why the FERC would not be able to provide the safeguards regarding power purchase or power and energy purchases and transmission and interconnections that you state in your testimony?
I don't have an opinion as to the effectiveness or the ability of FERC in any particular instance.
Okay.
And since we're talking about future things here, there's no way I could predict to what extent the FERC would or would not step in those questions. It certainly is something. Well, I'm sorry, I'll stop there.
Mr. Sandberg, I'd like to go back to your direct testimony, Exhibit 52.
Okay, give me a sec. Okay. Bear with me for my electronics for a moment, please.
Oh, no worries. Just let me know when you have it up.
Direct testimony, April 2/21. I'm there.
Would you go to page 58?
I will try to do so. Oops. Okay, I'm on what I believe is page 58.
Okay, and you see
Talking
lines.
about rate credits.
Yes, sir. Yes. Is it your testimony that the rate credits should be between $75 million and $125 million in this case?
That's what I said in my direct testimony, given the other things that have happened since then. If I were asked that question specifically today, what is your recommendation? I would say 125.
What's the basis for that $125 million number, Mr. Sandberg?
It's an attempt to roughly go 50-50 with the windfall that current PNMR shareholders, well, not current PNMR shareholders at the date of closing will get from the price to be paid to retire those stock issuances. It's roughly half of that.
Okay. Mr. Sandberg, is it true that today, as we speak, if somebody sells a share of PNM Resources stock there is no sharing of that gain or loss with ratepayers?
No, there is not.
Are you aware, Mr. Sandberg, that the New Mexico Public Regulation Commission has never adopted a guideline or a practice in which the gain or loss on the sale of an entire utility is not or is shared with, let me strike that. Let me start that sentence over again, that question. Mr. Sandberg, are you aware that the New Mexico Public Regulation Commission has never adopted any type of sharing mechanism between ratepayers and shareholders when there's a sale of a utility?
I don't have enough history to say ever or never by the commission. I don't believe they've done that explicitly in recent cases.
Mr. Sandberg, are you aware that in the past and as recently as 2008, the commission actually rejected the argument that there should be a sharing between ratepayers and shareholders when there's a sale of a utility?
I'm not aware of the 2008 case to which you are, I believe, referring in that question, no.
Can you name a single regulatory body in the United States that has agreed to the idea that there should be a split or sharing between shareholders and ratepayers when an entire utility is sold?
I have not tried to do that sort of national survey, no.
Mr. Hearing Examiner, I think I'm done.
Okay. You sure?
Yeah.
Yes, he is.
Okay. All right. Well, then let's go to Mr. Alvidrez. Mr. Alvidrez, you reserve seat.
Yes, thank you very much, Your Honor. Good morning, Mr. Sandberg. How are you?
I'm having a wonderful morning. Thank you for asking.
Well, you look very scholarly sitting there with your bow tie and the backdrop of the books. I'm assuming that that's a backdrop you've conjured up, that you're not quite sitting in a library with leather-bound books. Is that correct?
Objection, Your Honor.
Overruled.
The bow tie is real. I tied that myself this morning. The background is fake. Otherwise, you'd have to look at my very messy workroom, and that would be very distracting.
Well, it looks very nice. As I understand it, you're a photographer. Is that correct?
Yes, that is correct.
And in fact, that's what your current vocation is, as a photographer, right?
It is a significant portion of my current activities.
Okay. Well, you listed it in your resume. You have a photography business, right?
Yes, sir, I do.
And you don't have any other businesses that you fail to disclose on your resume, do you?
Businesses, no. Other things that I do, yes.
Well, other things that you do for remuneration?
Regrettably, no.
Okay. And as I understand it, you don't provide any legal services any longer, correct?
That is correct.
I was curious, in answer to some interrogatories, as I understand it, you actually reached out to New Energy Economy in connection with the PNM decoupling case. Is that correct?
Yes, it is.
And that's how you became engaged by New Energy Economy. Is that also correct?
Yes, it is.
And it sounds to me like you approached New Energy Economy. Am I understanding the sort of the process?
To give you an answer that is the whole truth. When I saw an article in the probably in the Albuquerque Journal regarding the decoupling proposal, I was so offended by what PNM was proposing to do that I began looking to find out what all of the public interest interveners in utility cases in New Mexico might be. And I looked at a number of those. PNM was one that I did contact and ultimately agreed to work with.
You said PNM, do you mean New Energy Economy?
I hope I meant NEE, yes.
Oh, okay. And as I understand it, you actually filed testimony in the decoupling case, correct?
I believe 2 rounds, yes.
Okay. You didn't testify because there was no hearing in that case, right?
The hearing that was scheduled has not taken place.
Okay, so this is your first time testifying, is that correct?
This is the first time I've been on the witness stand in front of the PRC.
Okay, and looking at your background, it appeared that at least leading up to your change of career to go into photography, you were a lawyer that worked in telecommunications issues, is that correct?
Among other things.
Okay, and in terms of your involvement in consulting now, do you consult with anyone else besides New Energy Economy?
No.
And as I understand it, New Energy Economy has paid you $5,000 for your work in total, is that correct?
In this case, that's correct.
Is it just in this case you've been paid $5,000?
Yes, sir.
And I think you described that as a pittance, is that correct?
I did use that word.
So are you anticipating that you'll be paid some additional funds in this case?
I do not know. We haven't. This is not an engagement that I have entered into for the purpose of making money.
Okay. Are you on the NEE board, or do you have any, involvement with NEE outside of providing testimony in cases?
No, sir, I do not.
I noticed that in your, primarily your initial direct testimony, you it contains citations to numerous cases and statutes, and you provide quite a bit of legal analysis in that testimony. Isn't that correct?
You'd have, well, you would have to be more specific. I don't know to what you're referring.
You don't recall citing to the Public Utility Act in your testimony, in your initial testimony in this case?
Well, that was 4 months ago, so I would need to go back, and you have to show me what you're asking. I'm sorry, I don't want to make a general statement without having some actual basis for it.
Fair enough. Let's go to page 9 of your testimony.
Okay,
And I'm talking about Exhibit 52.
Yeah. Page 9, I'm sorry.
Yes, yes.
Okay.
And you opine there about the sections of the Public Utility Act that are applicable in this case, right? At lines 20 and 21.
Well, I see on page, again, we're going to have fun with page numbers. I see on page 9 my recitation that the joint applicants asked to have the matter reviewed under sections 62-6-12 and 62-6-13. And after that, there is an answer that where I basically regurgitate subsections 12 and 13 into two one-sentence summaries.
Okay, and if we go to page 11 of your testimony, you give your analysis of a number of New Mexico PRC cases involving acquisitions and mergers, right?
Objection to that. He gives his analysis. That's not what the testimony states.
Well, can I, you list the conditions to be considered, right? That's your opinion, the conditions to be considered when determining the public interest for whether an acquisition is in the public interest, correct?
Objection
No, sir.
again, that misstates the testimony. The testimony says that these are the conditions listed in 19234 UT. It is not his opinion.
So what's in
You're
your,
just trying to be more specific in your questions.
well, let's look at page 11 on line 3. The question is, are those the only conditions that the commission in past acquisition cases have considered to ensure that an acquisition is in the public interest? Do you see that?
I see that question.
And then you provide a lengthy answer where you talk about what the holdings were in case 1900234 UT, correct?
Objection again. I believe that the testimony specifically says this is what the hearing examiner in case 19234 UT, those were the conditions that she delineated, not that Mr. Sandberg did. It is not his opinion. This is
Overruled.
I'm sorry, counsel, I don't have your actual question in my head now.
Well,
I
was
apologize.
No, there's been a lot of interruption. I was asking on page 11, line 3, at least on the version that was uploaded. I don't know if that matches yours, but
Strangely enough, it does.
well, that's helpful. You provide a list, in your opinion, of what the hearing examiner in case 1900234 held were conditions to be considered in determining the public interest, correct?
I don't think that's correct.
Okay, well, what are you doing there?
You said I provided my opinion of what the hearing examiner did. And in fact, my testimony is that the hearing examiner listed a number of conditions. And I basically lifted this. I didn't review or analyze or change. These are just the conditions that the hearing examiner listed in the amended certification. This is, I'm being a reporter in this circumstance, not an analyst.
Okay, but you do analyze using those conditions in this case to give your opinion about whether the appropriate conditions have been met with respect to the proposed merger. Isn't that correct?
I do later on, yes.
So you're giving your legal opinions in this case about whether there's been a sufficient showing with respect to the proposed merger. Isn't that correct?
As I said very early in my direct testimony, the dividing line between law and public policy in utility matters is a wonderfully wide and gray boundary line. I believe that my testimony here is attempting to use my years of experience in the public policy making of utility regulation to say, if you start with those conditions, what happens when you look at this proposed transaction?
Well, let's go to page 36 of your testimony, same testimony.
Yeah, I'm scrolling. there's a question in the middle of the page, what should the commission do here about FCPP?
Yes, but I'm going to start at 6, line 6.
Understood. I
right?
was just trying to make sure we had the same page. I see line 6, the law is clear.
Right. So you're
Okay.
giving your legal opinion there about what the cases that follow hold with respect to, in this case, prudence disallowances, right?
Given the clarity of the court's statement in that case, I'm not sure I'm actually opining as much as just reciting that an inescapable statement by the court.
Well,
I think anyone who read that case would see the same language.
So it would take no particular expertise to look up the cases and find the pertinent sections and then recite them in testimony. Is that what you're saying?
That's a highly compound question. I don't know what expertise would be required necessarily, but I believe there would be some to at least locate the case. Whether you could whether the typical man on the street would be able to find the relevant passage is an open question. I do not know. But I believe that anyone reading ratepayers are not to be charged would believe that the court said ratepayers are not to be charged.
So let's move on. On page 59 of your initial direct testimony.
Let me scroll, please.
Okay.
And then go too far. Okay, page 59.
So yes, you provide a list of what you believe are appropriate conditions that if the commission decided that it was going to approve the proposed merger, you would want this specific set of conditions imposed, and it goes on to page 60 as well, right?
You have summarized the testimony right.
I beg your, okay.
You have given an accurate summary.
And as a matter of fact, in the course of this case, your recommendations have really been evolving, haven't they?
Absolutely.
And you just gave an example. Originally, your opinion was that a $75 million rate credit would be adequate, but now today, for the first time, you say that 125 million is what it would take, right?
That
Objection, I believe that misstates his testimony, and it's in black and white that he says 125 million.
Sustained.
Well, isn't it also in black and white that you said a range, and the lower range being 75 million would be adequate?
I suggested a range initially between 75 and 125. That is correct. My opinion is that the high end of that range is most appropriate.
Okay. And you've added some other issues that you didn't have in your original testimony. In fact, they were struck from your rebuttal testimony, were they not? Because they were new issues that you raised on rebuttal for the first time?
That was the argument used.
And that argument prevailed, did it not?
Testimony was redacted.
Have you ever heard the phrase of moving the goalpost?
I believe I probably have.
Okay. And what that means is that, someone will set up a specific goal or standard, and then when the party trying to achieve, either achieves or come close, then the standard is raised, right?
I don't know that that's the definition that I would use for a general concept of moving a goalpost. No.
All right. Well,
Hold on, let's take a 15-minute break now. Let's break and come back at 11 o'clock. We're in recess till 11 o'clock.
Mr. Lee, have I given you any acronyms or things that didn't come out well in the transcript?
No, sir.
I was taught many years ago to be nice to court reporters.
And I accept that gratitude on behalf of all reporters.
There was a crotchety old reporter in Minnesota who, if you were not nice to him, would put in all your ahs and ums and pause in the transcript.
I'm afraid I'm not that punitive. When you're ready, Judge.
Okay, Mr. Alvidrez, are you there? There you are.
Your Honor, I am here. Before we get back on, are you able to hear me?
Yes.
Before we get back to cross, I was able over the break to look into the question that you had asked about independent board of directors with respect to PNM resources. And I'm advised that really the best source for that, and it provides it in a very succinct way with the name of the various directors, their age, how long they've been directors, their occupation, what committees they serve on, and other public boards that they serve on, can be found in the 2021, the most recent PNM proxy SEC filing. And so with your permission, what I would propose is that we would accept your verbal instructions this morning as a verbal bench request and file, actually it's page 6 of the proxy statement that has all of the information and more that you requested, if that's okay with you.
Does that indicate they qualify as independent under the rules of the New York Stock Exchange?
Yes, sir.
So you would file an exhibit?
Yes, sir, we'd file a response. We can include the entire proxy statement if you would like, or just the specific page. I mean, I can show you the page. I'm not sure how clearly it would come across, but as I said, it provides all the information and more that you requested this morning.
Okay. Well, that will satisfy me. Could you scan that page and distribute it to the parties and to me, and we'll address its admission, I guess, after lunch.
Mr.
Yes,
Hearing Examiner?
Yes, Mr. Albright?
Yes, I had planned on asking to file or to take administrative notice. Didn't look from what Mr. Alvidrez was holding up that it is that long a document. If it's, I would say, 10 pages or 15 pages, that he just include the entire document so we could take a look at it in its entirety.
I'm happy to do that if you want that in the record. It's also publicly available, so anyone can click on PNM's website and look at the whole document. So whatever your pleasure is, Your Honor.
Well, if you could scan, how long is the document?
It's 80 pages, not including cover, 80, 81, 82, 83, 84.
Scan the page that has the information that you're talking about. That's all I'm going to.
I would agree with that, Mr. Hearing Examiner. Thank you.
Okay, sir. We're happy to do that. Thank you.
Well, thank you. Okay, continue with your cross-examination, Mr. Alvidrez.
Yes, Mr. Sandberg, as I understand your testimony, in connection with your analysis, you rely heavily on final order and recommended decision in the El Paso Electric Sun Jupiter case. Is that correct?
I certainly have.
To the form of the question.
Ruled.
Answered the question. And
I didn't hear the
I
answer.
understand-
I think
What
you
was your
didn't hear
answer,
it
sir?
because I never gave it.
Oh, I thought you said yes.
No, I did not.
Oh, I'm sorry.
No, I apologize for the trying to talk over each other issue. My answer was intended to be, while I certainly referred to that case, your characterization overstates it.
Okay. So you wouldn't describe this, the recommended decision and final order of the EP Sun Jupiter case, sort of your benchmark in analyzing merger requirements?
It's certainly something I took into account. I don't, that's all I can, no.
Let's go, if we can, to your Exhibit 54.
I'm sorry, when you say Exhibit 54, do you mean NEE's Exhibit 54 or one of my attached exhibits?
No, sir, I'm talking about NEE's Exhibit 54.
Okay, give me a sec. The July 16th testimony on the stipulation.
Yes, sir. And
Okay, I'm there.
you've got, if we look at the table of contents on page
Yes, sir.
1, you have specific enumerated issues that you've identified with respect to the second amended stipulation. Is that correct?
Yes, sir.
I want you to look at issue number 10. That's begins
Okay.
on page 53 of your testimony.
Let me scroll down,
Okay.
please. I'm not as, let's just say I have more than one or two windows open and my clicking is not always as accurate as I'd like it to be. Okay, issue number 10, I have on page 54.
Okay, and as I understand it, what you're advocating in this section is some sort of guarantee for adequate cleanup and plant remediation at San Juan and Four Corners. That's what the heading.
Yes, sir.
suggests.
That's what it says, yes.
And this, again, this is one of those issues that you didn't raise in your initial direct testimony, correct?
I don't believe so, no.
So it was added later after reading testimony from some others, right?
Well, and after seeing the second amended stipulation.
Okay.
However, before I finish that answer, I'm trying to remember back to direct. Again, the difficulty with things that you wrote 4 months ago is that you don't always have them in the top of your head. Let me just make one quick look back to okay, I'm sorry, please ask your question again.
My question was, this is a topic that you did not cover in your initial testimony, correct?
I don't believe I was at this level of specificity. No, that's correct.
Well, you didn't talk about it at all, did you?
Well, that's what I'm trying to parse back from the direct testimony, because on page 9, lines 5, 6, imposition of meaningful conditions. Yeah, I'm not sure that this was, well, it is clearly not at the level of specificity as in the later testimony. Let me just go with that.
All right, and I was unclear about what you're talking about here, because you talk about paragraph 56 in the second amended stipulation, which deals with decommissioning, and your issue number 10 talks about cleanup and remediation at these plants. Do you understand a distinction between the two?
I think there's a distinction without a difference. Obviously, you cannot abandon and walk away from those long-running plants without providing for remediation, cleanup, tear down. Walking away is not the end of the process.
Okay, so when you're talking about cleanup and plant remediation, you're not talking about environmental cleanup or remediation. Is that correct?
I think I am.
Okay.
I mean, that would certainly, I'm sorry. I cannot imagine that you can consider the closure of a long-running coal-fired plant not to include remediation of whatever environmental issues are in place at the day you close it up.
Okay. But you have no facts that suggest that the owners of the San Juan Generating Station would not do whatever environmental remediation was legally required, do you?
I have no way of knowing what their intentions are. When someone says good faith efforts, it causes me to wonder what they are trying to avoid.
You don't have any facts that they're trying to avoid anything, do you?
I do not know what their intentions are.
And isn't it also true that the decommissioning is a contractual matter as among the owners of the San Juan Generating Station?
Oh, I think that is part of the issue. I suspect that both state and federal environmental agencies might think that they had some stake in the matter as well.
Okay, but the New Mexico Public Regulation Commission has no jurisdiction over environmental remediation. Isn't that correct?
That's a very broad statement, and I don't think it's completely accurate. I think the commission does have a stake in that issue because it may be asked, what should we do with the costs that we've incurred in the remediation? And that would be an issue within the commission's purview, I believe.
So the commission has jurisdiction over cost recovery, but it has no jurisdiction to direct that any specific type of remediation be undertaken, correct?
That's a legal question beyond my ability to answer.
Okay. In terms of Four Corners, I guess your answer would be the same. You have no facts to suggest that the owners of Four Corners would not comply with applicable requirements in terms of any remediation that might be necessary, right?
I also do not know what the intentions of the folks who will be the owners at the time that plant eventually closes may be today. I do think I touched on the question of would at least one of those owners be financially stable at the time, and that answer probably could apply to any of the owners. If they are not financially stable at the time, then there will be a major problem with doing final remediation.
But that's speculation, right? You have no facts that any owners are going to be financially unstable at the time the plant is retired in 2031, presumably.
It's impossible to know today what the financial condition of any of the owners will be at the time. However, there certainly are, based on public reporting, some questions about the financial ability, at least today, of one of the owners.
So you're aware that El Paso Electric was a longtime part owner of Four Corners, right?
I can't answer the question as to long time. I do know that at least at some period of time they were.
And there was no requirement in the approval of the El Paso Electric Sun Jupiter case that El Paso Electric take any include any special provisions with regard to Four Corners decommissioning or remediation. Isn't that correct?
I'm sorry, include any special conditions.
Relating to remediation or decommissioning.
I don't recall at that level of detail what a condition, whether that such condition was or wasn't.
Issue number 6 on your July 16 testimony deals with rate freeze, right?
Now you got me. I got to get back to the top. Hang on. Issue number 6, rate freeze. Okay, I see the heading. Let me get down to that section of the testimony, please. Okay, I'm on page 41, issue number 6.
And that, as I understand your testimony, you regard it as a fatal flaw in this proposed merger, is that there was not a specific rate freeze being offered up as a regulatory condition. Is that right?
I think that is a very serious shortcoming.
And isn't it true that a rate freeze may be one element that the commission can consider in terms of whether there's a benefit, but the absence of a rate freeze is not something that would automatically disqualify a given merger transaction. Isn't that also correct?
I don't know that that is necessarily true. It certainly has been an important issue in the cases that I had seen from earlier commission decisions. I don't know that the commission has ever expressed a statement as clean as you're asking. In other words, without a rate freeze, could there be approval? I don't know that that's ever been actually stated.
Okay, so you have no opinion on that issue then?
My opinion is that it certainly has been an important issue, an issue of significant importance in earlier cases.
Well, you understand that the joint applicants have now agreed to a rate freeze as a condition in this case, right?
I have great difficulty in being able to say exactly what it is joint applicants have actually agreed to with all the moving of goalposts after the filing of the second amended stipulation. I know that there has been testimony that there will not be a rate case for a period of time, which may be the same thing as an interim rate freeze. And if those two words mean the same to the joint applicants, then I do understand they're talking about a short-term period during which they will not ask for a rate review by the commission.
And that's similar to what the situation was in the El Paso Electric case, right?
I think that is correct, yes.
And you talked about moving the goalposts, and in terms of the joint applicants, they're actually moving the goalposts closer to the players, aren't they? In terms of providing additional benefits.
I think that's a very difficult generalization to make accurately. What I have seen, and understanding that NEE has not been involved in those post-second amended stipulation negotiations, what I have seen are individual interveners saying that PNM joint applicants have agreed with us on certain things. I've also seen testimony by some of the interveners. I'm thinking, I think it's WRA, that say, well, we don't necessarily agree with everything everybody else is doing. So it's very difficult to say that it has become better when A, I don't really know what it is, and B, at least some of the parties may not think it's better.
Well, in terms of the rate relief, that has certainly grown from what was originally proposed, has it not?
It has.
And the relief with regard to arrearages due to COVID-19 has also grown substantially.
It has grown.
Okay. So those are positive things, correct?
When you have as many moving pieces as there are in the attempt to reach a resolution other than going to the commission for an answer, it is very difficult for me to say, well, these one or two things have improved, therefore the whole thing has improved. Taken in isolation, those two issues you identified, I agree that that the joint applicants have sweetened the pot on those two issues.
So turning to issue 3, this is your claim about there being insufficient consumer protection.
Oops, hang on.
And the need for adequate reliability and safety standards and penalties for underperformance, beginning at page 31 of your rebuttal, your July 16 testimony.
I apologize. I just scrolled the wrong document and completely lost my place. I apologize. Let me get back to the correct document. The joy of having too many items of testimony at the same time. Okay, I'm on issue 3. Yes, sir.
And here, basically, you're essentially adopting the recommendations of staff on this topic, right?
I very much agree with it. Yes.
Okay. And regulatory commitment 36 of the second amended stipulation addresses what the joint applicants are willing to do with regard to reliability issues, right?
I believe that is correct.
And you yourself haven't done any independent analysis of PNM's reliability metrics based on SAIDI and safety, have you?
Other than reviewing the materials that joint applicants provided regarding their extensive failures and their extensive penalties in other states, and looking at the some of the NERC materials, I don't know if that qualifies to your question or not, but I certainly have looked at the time I was preparing the testimony, I did look at things. Yes.
No, it's not responsive to my question. I said an independent analysis of PNM's reliability.
Oh, I'm sorry, sir. I did misunderstand the question. No.
And you understand, based on the testimony in this case, that PNM's reliability metrics place it in the top first or second quartile among the 84 utilities that were the subject of the Edison Electric Institute survey, correct?
I believe I recall seeing that testimony.
And you also understand that PNM and El Paso Electric have similar reliability metrics measured on SAIDI and safety, right?
I'm sorry, I don't have in my head a way to compare those two, no.
You don't have any recollection of how PNM and El Paso Electric compare?
At this point, I do not have that recollection, no.
Well, the record will show what that is, but you would agree that in the El Paso Electric Sun Jupiter case, there was no requirement or system for penalties for El Paso Electric failing to meet any specific reliability metrics. Isn't that correct?
In the context that there was no suggestion that things would go south post-acquisition because of the acquiring company's history, no, I don't think that was imposed.
And in terms of issue 5, this has to do with your arrearage relief proposals.
Okay, I am scrolling down to that.
beginning at page
Yes.
36 and 40.
I got it.
And this again was one of those new issues that you brought up during the course of the proceedings. This was not an issue you raised in your initial testimony, right?
Well, let me go back and look. Other than on page 9, lines 1 through 3, where there's a general statement I make about comporting with minimal benefits in other recent merger cases, I don't believe I went to this level of detail. No.
Well, you don't mention arrearages at all, do you?
I'm sorry, sir. If you want me to verify that, I will go back and read the testimony.
Okay.
I do not recall. I'm trying to agree with you as best I can, which is I don't believe I went to that level of detail. But I would need,
Okay.
if you want a yes or no answer, I'll go back and read.
I have limited time, so let's move on. You are now proposing that the joint applicants pay the entire outstanding balance for residential customers with respect to arrearages, correct?
Yes.
And that's irrespective of whether they're COVID related or not COVID related, isn't that correct?
As I said earlier this morning, yes, that's correct.
And you understand that the joint applicants are now, if this merger is approved, will provide an additional $10 million in arrearage relief, right?
I believe that is the current state of things, yes.
And PNM has already provided $2 million of shareholder money to be applied towards arrearage relief related to COVID, right?
Yes, that's correct.
And you're not aware of any other New Mexico utilities, the other investor-owned New Mexico electric utilities that have indicated that they're going to pay for, at shareholder expense, for COVID relief, any COVID relief, are you?
I'm not aware of any pending mergers or acquisitions of other New Mexico IOUs.
So this is only because there is a proposed merger that is contemplated that you think it's appropriate for the company, the joint applicants, to pay off the COVID debts?
Consistent with the statutory, I'll play lawyer if you want to characterize it that way, but the statutory requirement that the commission balance the interests of owners and ratepayers, yes, I do.
Well, that standard applies whether you're going through a merger or not, right?
I think it does.
So is it your testimony that the other utility companies, the other electric utility companies, should pay or wipe out, I think is how you phrased it, all of the COVID arrearages?
I have expressed no opinion about anyone else other than the joint applicants involved in this proceeding. And I don't know that there are any other situations that are currently the same for other New Mexico IOUs. This is a unique circumstance.
And you don't think the other utilities have arrearages caused by the COVID pandemic?
I do not know.
Okay. And you can't say that the $10 million coupled with the $2 million previously provided by PNM shareholders will be insufficient to address the ultimate arrearages related to COVID, isn't that correct?
No, I believe Mr. Darnell testified that we're over 20 million of arrearages. So I don't think 12 makes 20.
Well, didn't Mr. Darnell also say that there are other funds available to address arrearages, and that with the combination of what PNM, the joint applicants are proposing, and those other funds, that he would expect that would fully satisfy the residential arrearages?
Well, since Mr. Darnell cannot in any way control what other parties may or may not do, I really don't think his opinion is of much value.
Well, are you aware of what other programs are available for payment of utility arrearages due to COVID?
Not specifically, no. I'm not aware of any obligations of any other parties to fund PNM arrearages.
I want to talk a bit about issue 8, which is an independent evaluator.
Okay, let me, what page are you on? I'll go that way. I won't go back to the top.
48 to 50.
Thank you. Okay, give me this. I'm almost there.
Yeah. And,
Okay, thank you. I'm there.
and before I get to that, you would agree, would you not, that the $10 million that the joint applicants are willing to pay for arrearage relief is a form of customer rate relief?
Yes.
So when we look at the $67
I'm sorry.
million,
I'm sorry. Counsel, I'm sorry. I need to finish that answer a little more than you saw me pause and try to think through it. May I complete my answer?
well, I saw you answer it, and now
Well,
it looks like you're having
I
a
understand
second
that.
thought.
I'm asking your consideration of letting me complete an answer that I really had to think hard before I could put it together. It's up to you.
No, let's hear your new answer.
Yeah. But my answer is yes, so long as there is no vehicle by which PNM ever puts any of those dollars into a rate request.
Okay, fair enough. And you understand that the $10 million that the joint applicants are proposing would not be included in rates, right?
I understand that is the way it's been presented. I'm not arguing about it. I simply want to be clear.
Okay. So when we look at what is now the $67 million in rate credits, plus the $10 million in arrearage relief, we're up to $77 million in just those two items alone in terms of rate relief in this case, right?
I disagree with your definitions.
What do you disagree with?
You're going to go back and say, well, 75 to 150. The 75 to 125 was purely rate credit on bills. It did not include any consideration of other ways in which PNM or the joint applicants might add conditions to a proposed settlement.
Well, you just testified that the $10 million, so long as it's not put back in rates, is a form of rate relief, correct?
I did. That is distinct from the concept of a rate credit.
Okay. Let's now turn to the independent evaluator issue.
Yes, sir.
And that's regulatory commitment 34.
I believe that is correct.
Okay. Do you understand that PNM currently has an affiliate that participates in requests for proposals for new generation resources?
I believe that is correct.
And so the merger is not going to change the fact that there are affiliated interests that have the capability of participating in RFPs for new generation, right?
No, I don't think that's correct. You pointed out, or sorry, you asserted that there is an singular affiliate, and you correctly noted that post-merger there will be opportunities for plural, multiple affiliates. I think that's a significant distinction.
Okay, so there's more affiliates that will be, I guess, available to participate in RFPs, right?
I believe that to be true, sir, yes.
Yeah, and you know, there has been expressed in this case a heightened concern that Avangrid Renewables, as a major player in the renewable resource market, you know, may change the playing field a bit, right?
I believe that has been expressed.
And you're also aware that in terms of the regulatory commitment for an independent evaluator, that is the first time that any New Mexico utility will have been subject or will be subject to the use of an independent evaluator in a resource selection and recommendation.
Objection, that misstates the facts.
Overruled.
Council, I do not know what every other utility in New Mexico may or may not have been required to do. I'm sorry, I do not know.
Okay, all right. So that you haven't looked into the independent evaluator issue in New Mexico?
That's correct.
I was curious. I mean, in your direct testimony, you cite to other states, Ohio, and I don't remember them all, but you cited to at least 3 other states that
I recall Hawaii,
you
for
described as
example, yes.
utilizing independent evaluators. Is that correct?
I'm sorry, you cited to at least 3 other states that
Utilize independent evaluators.
I do recall that. Hawaii sticks in my mind as we speak.
Okay, but you looked at other states, but you didn't look at New Mexico?
That would not be a correct statement.
Well, what
I can
did you look
correct it.
at?
Thank you. I looked for reports of states generally, no restriction, that have moved ahead with independent evaluator processes. Those that I listed in my testimony were ones where I found a reliable source, typically the commission itself, to verify that they were in fact using or in the process of independent evaluators. I did not exclude New Mexico from that search. But it's sort of ipso exclusio. I'm not finding anything relating to New Mexico. I did not cite to anything about New Mexico.
All right. In terms of the independent evaluator process that's proposed in the regulatory commitments, you understand that an independent evaluator will be utilized whether any affiliate participates in the RFP process or not, right?
I believe that is correct.
As I understand your testimony at page 50, line 8, though, you take issue with customers paying the cost of the independent evaluator when no affiliate is involved in the RFP. Is that correct?
That's not quite what it says. It doesn't say when no affiliate is involved. My understanding of the condition is that if an affiliate does not actually put in a bid at the RFP, that's the point at which costs would be shifted to ratepayers.
Well, I mean, that was a concern. You referred to it as there's a potential for gaming, I think is the phrase you used, is it not? Did you not use the phrase gaming?
I'm looking.
10 minutes, Mr. Alivas.
Thank you, Your Honor.
I'm not finding the word right here, but I would agree that that is the concern.
So we now know from the clarified commitments that PNM would advise at the beginning or whether or not an affiliate was going to be a participant in the RFP process, right?
I don't have that level of detail in my head. I'm sorry.
Well, if it was announced at the beginning of the RFP process that an affiliate was going to be participating, that would eliminate your concern about gaming, would it not? Because everyone would know, okay, they're gonna participate, and so this is going to be, the cost will be absorbed by PNM.
If that announcement that you're describing triggers an irrevocable decision that ratepayers will not pay for the evaluation of that evaluator in that RFP, then yes, I would agree.
Okay. And in situations where there is no participation by an affiliate, it would be appropriate for PNM to be entitled to recover the cost of the independent evaluator, would it not?
I think that's a policy question for the commission, given the nature of post-merger PNM within the Avangrid family. I can see why there would still be just general concerns. If the commission were to say that a RFP with absolutely no involvement by any affiliates of the utility, yes, I would be comfortable with that going in as a claim for an expense in PNM's next rate case.
Turning to issue number 1 in your July 16 testimony with regard to the Four Corners power plant.
Yes, sir.
As I understand it, you're challenging the approval of the merger based on PNM's proposed exit from Four Corners at the end of 2024 and the proposed securitization of related abandonment costs, right?
I think the better way of saying that is the last part of your question, that the problem is attempting to put the roughly $300 million onto ratepayers that result from the merger decision and the abandonment of Four Corners.
So it's the cost recovery aspect that you find objectionable, not you don't object to PNM exiting Four Corners, is that correct?
I may have many personal objections regarding the way that PNM is attempting to say it's getting out of the coal generating business, but as to the conditions and the proposed second amended stipulation and the proposed merger, the issue is $300 million being placed on ratepayers.
So you're aware that PNM was in fact planning an early exit for Four Corners before there was ever any discussions with Avangrid or Iberdrola about a merger, right?
I think the record is much more complex than that.
Well, do you have any facts to suggest that the discussions about exiting, the discussions by PNM about exiting Four Corners did not occur before the discussion started with Iberdrola on a merger?
What I can point to and what I think is probative on that general question is the timing and the communications between Iberdrola and PNM's representatives. The fact that the agreement with NTEC was burned into the purchase agreement with Iberdrola, and the overarching requirement by Iberdrola that PNM be able to say it was gone from Four Corners in order to get a deal with the only suitor that PNM actually had.
But that mischaracterizes what the evidence is in this case about the exit from Four Corners, right? The evidence is that the exit from Four Corners is not a condition for closing on this merger, right?
That is slicing the bread extremely thinly. I agree that, among other people, I'm sorry, it is the testimony of at least some of the joint applicant witnesses that a failure to I'm sorry, I'm losing my thread here. Can I need to, can you please repeat the question? I want to make sure I'm answering the question you actually posed.
Mr. Lee, can I have you please repeat my question?
But that mischaracterizes what the evidence is in this case about the exit from Four Corners, right? The evidence is that the exit from Four Corners is not a condition for closing on this merger, right?
Joint applicants have testified that.
Objection. I'm sorry. Mr. Lee, this is Jason Marks. Mr. Shiner, I'm sorry to object, but that's a compound question. He asked about two different things. His preceding question that he was following up on was that the evidence, Mr. Alvidrez was representing it. The evidence in this case was that PNM was engaged in exiting Four Corners before the merger. Then when he re-asked the question, he started off by asking the witness to confirm that, but then he switched to a different question, which is the evidence in this case that completing the spinoff is not a requirement for the merger to go through. And so I think it'll be unclear which of those questions the witness is answering. And I have no objection to him answering the second question Mr. Alvidrez asked, if that's the question.
Sustained.
I'll rephrase the question, Mr. Sandberg. Both Avangrid and PNM witnesses have testified in this case that the successful abandonment of the Four Corners power plant is not a condition to closing on the merger. Isn't that true?
Objection,
believe they have.
it states the evidence.
Overruled.
I
And
believe they have testified to that.
And likewise, Mr. Darnell has testified that even if for some reason the merger doesn't go through, that PNM will continue to seek abandonment in the pending abandonment case, correct?
I don't have that testimony in my mind. I'm sorry, no.
Okay, so you don't recall whether that was a testimony?
I'm sorry, I do not.
Okay. Now, one of the assertions in your testimony is that certain costs for which PNM is seeking recovery in the abandonment case were imprudently incurred. Is that a correct understanding of your testimony?
It is.
And that's based on a recommended decision that was issued in case 16-00276, that what I'll call the 2016 PNM rate case, right?
That is correct.
And you also know that recommended decision was ultimately not adopted by the New Mexico Public Regulation Commission. Isn't that correct?
Objection,
Not the way
that states the final order in the case.
Overruled.
That's not the way I would describe it.
Well, the issue of Four Corners imprudence was to be deferred to a later case, correct?
Yes, sir.
And in fact, in case 21-00017 UT, which is pending right now, the issue of imprudence with respect to Four Corners is being litigated, correct?
I believe that is an accurate statement of of that case without getting into the arguments that have been raised by parties about the ETA.
Mr. Avangrid, your time is up.
Okay, I appreciate it. Thank you very much, Your Honor. Thank you very much, Mr. Sandberg.
You're welcome, sir.
Okay, is there any
Excuse me, I didn't hear what you said.
is there any redirect, Ms. Nancy?
Yes, I have a couple of questions. Thank you. Mr. Sandberg, would you go to joint applicants exhibit 2, which is the notice of filing, the second amended stipulation, and please go to page 22 of 45, specifically paragraph 17, management.
Bear with me for a second. I need to get down to, okay, joint applicant exhibit 2. Okay, I have that. What page, please?
22 of 45.
Okay, give me a sec. 18, 20. All right, I am on page 22 of 45.
You were asked a number of questions by both Mr. Haverly and Mr. Alvidrez about PNM board and PNMR board. Is it your understanding that the PNMR board is the one that it's PNMR stock, and that board, that PNMR board, may have independent directors?
Well, I think there's been some murkiness in questions I was asked earlier today, but certainly there is a distinction between the PNM board and the PNMR board. And what I see in the numbered 17 statement on page 22 is the commitments go to PNM board.
And is the PNM board, if the merger is approved, does the PNM board issue stock?
What an interesting question. PNM will continue, will be a wholly owned subsidiary of PNMR, as I understand the final structure. And then PNMR is owned upstream by Avangrid, it's owned upstream by Iberdrola. I would suspect there is a single issue, there's a single stock certificate that would be somewhere in a filing cabinet with PNMR's name on it.
Is it your understanding that PNMR, if the merger is accepted, will cease to exist, and that the holding company will be Avangrid?
I am not confident that I can answer that question accurately, given the convoluted structure that was proposed in the company's filing.
But as you understand what commitment number 17 states, this is all about the PNM board of directors and has nothing to do with the holding company. Is that your understanding of the words in commitment number 17?
All I see in 17 are commitments related to PNM.
You were asked a specific question about splitting the difference between shareholders and ratepayers and dollars to be received as credit. Could you explain what your understanding is of the law about the balancing of interests and how you determined what benchmark you used to determine your proposed rate credit.
I will certainly try. I want to start by being clear, and I did not in any way intend to say that any money should be moved from the windfall right going to stockholders of record. I simply was trying to say that amount of windfall should be the benchmark to say what would be appropriate for ratepayers. And you're right, I do believe that the statutory direction for the commission to balance the interests of owners and ratepayers plays out here as well as many other places in the PRC's work. My idea was and is that, and I think Mr. Hempling even agreed with this, that it would be a reasonable approach to say, let's find at least half of the value that ratepayers, that stockholders are going to get, and move that in an appropriate way to say that is the amount that ratepayers should receive from the same transaction.
In your July 16th testimony and your July 29th testimony, the title of it is the testimony and exhibits of Christopher Sandberg in opposition to proposed transaction and second amended stipulation. Is that correct?
Yes.
And so in your testimonies, both the July 16th and July 29th, you weren't referring to new topics. You were referring to not only the merger, but the second amended stipulation as filed, correct?
Objection, Your Honor. Leading objection, Your Honor. That was a leading question in proper form.
Sustained.
So let me just ask you, is it true that in the July 16th and July 29th testimonies, you were responding to the second amendment stipulation as well as the merger?
Yes.
Were the quote unquote new topics in response to the second amendment stipulation?
I believe that that is where a number of issues came to the forefront that had not been present in the initial filing.
Thank you. That's all I have for a redirect.
Okay. Thank you, Mr. Sandberg. Thank you, Tony. You're excused.
Thank you, Your Honor.
Okay, let's try and move on to Mr. Dauphiné.
Yes, Mr. Hearing Examiner Kelly Gould for New Mexico Affordable Reliable Energy Alliance. Let me call Mr. Dauphiné right now.
Okay.
He should be joining the Zoom momentarily.
And the ink in my pen just ran out. It shows you we're near the end. Huh?
If I may, while we're waiting for Mr. Dauphiné, Mr. Hearing Examiner and Mr. Lee, I would like to introduce myself and enter my appearance for the record. On the Zoom screen, it says Peter Gould, but in fact, my name is Kelly Gould, spelled the same, Gouldkelly, and I represent New Mexico Affordable Reliable Energy Alliance, also known as NM Area. Thank you.
Hey, I just admitted Mr. Dauphin. There he is, Mr. Dauphin. Go ahead, Ms. Gould.
I'm just going to wait for a moment to make sure that Mr. Dauphiné's audio is connected.
Muted right now.
Would you
Good
please
afternoon.
raise your right hand? You
Yes.
solemnly swear the testimony you're about to give in the matter and opinion will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Dauphiné.
Good afternoon.
Can you please introduce yourself and spell your name for the record?
I'm James R. Dauphiné. That's DAUPHINAIS.
And who are you employed by?
Brubaker and Associates, Inc.
What is your job title?
I'm a consultant in the field of public utility regulation, and I'm a managing principal of Brubaker and Associates, Inc.
And who are you providing testimony for today?
New Mexico Affordable Reliable Energy Alliance, or NM Area.
You have in front of you what has been marked as NM Area Exhibit 2, titled The Direct Testimony of James Dauphiné, filed on behalf of New Mexico Affordable Reliable Energy Alliance, filed on April 2nd, 2021.
Yes.
Is this a correct copy of your direct testimony filed in this case?
Yes.
Was this document prepared by you or under your supervision?
Yes.
If the same questions were asked of you today, would your answers be the same?
Yes.
And those answers are true and correct to the best of your knowledge?
Yes.
I ask the hearing examiner to move into evidence NM Area Exhibit 2.
Is there any objection? NM Area Exhibit 2 is admitted.
Thank you, Mr. Hearing Examiner. I pass the witness for cross-examination.
Okay, Mr. Albright, you reserve 10 minutes.
Yes, Mr. Schoenauer, thank you. Mr. Dauphiné, good to see you again.
Good to see you as well, sir.
I'm Jeff Albright with J. Albright Law LLC, representing the county. Just a quick question, and I probably won't be granted extra time by the hearing examiner, but I noticed that in your resume that you had some interface at the Millstone nuclear power plant there in Connecticut.
Yes, that's correct.
Is that correct? We do have something in common in that when I was getting my master's in electrical engineering out at Monterey in 1976, we looked at some transient issues that arose with regard to load involving the Millstone nuclear power plant. And it turned out that on weekends in particular, when loads from large industrial folks were not being using it, that we had these transients in the system. So perhaps we can chat about that at some time. And I was wondering if in 1996, 97, when you were involved there, if that was a similar situation or if it was something entirely different.
Yeah, I'm not familiar with the specific thing you're raising, so I don't know.
Okay, just curious. So I won't take more time because, as I say, I'm probably down to about 8 minutes now on questions. I would like you to turn to page 5 of the testimony.
I'm there.
Okay, and you have, there's some quotes there with regard to the integrated resource plan. Do you see those?
I do.
When it speaks at line 9 of the existing bulk transmission system alone, what is that referring to?
PNM didn't define that term in their IRP. They had a Appendix B that had a glossary of terms, but it wasn't listed there, nor did they define it in their Appendix E, which listed their transmission facilities. I would read it to be the equivalent of the NERC definition under the NERCs. That's the North American Electric Reliability Corporation. Their glossary of terms under bulk electric system, which would include transmission elements 100 that are operated at 100 kV or higher, unless they are utilized only for the local distribution of electric energy.
So in general, would that be for export out of the state, that kind of transmission? Or are we talking in-state transmission lines that eventually feed into the distribution?
It's actually both. It's both the transmission facilities that utilize power from PNM's generation resources to its load, as well as those same transmission facilities, which are also utilized to both bring in purchase power from the wholesale market or to export power from the PNM system to the wholesale market.
Okay.
The facility, the power is all commingled on the transmission facilities.
Okay, so there's also been discussion about either tying into an RTO, operating the regional transmission systems, or a priority with regard to developing one or becoming a member of. Do you recall that testimony?
I do, but I would note that I'm not an emeritus witness on the RTO issue.
Okay, all right. Do you have experience with RTOs?
I do.
There was some representation made about SPS being part of the SPP. Do you know if, but that is not an RTO that's in the Western region, correct?
The
Southwest Power Pool?
The Southwest Power Pool does not currently operate a regional transmission organization in what's called the Western Interconnection. That's correct.
Okay. Is there anything that would preclude a company from participating in more than one RTO?
I've never heard of a situation. Well, if a utility had separate service territories, they could potentially participate in different RTOs. The example I would think of would be Northwestern Corporation, which has a South Dakota service territory and a Montana service territory, and they're not connected to each other. So those could be in separate RTOs. But other than that, I'm not aware of any situation where a given utility could be in two different RTOs at the same time.
Okay. On page 7 of your testimony, you have.
I'm there now.
All right, with referring to the insurmountable at lines 9 through 15, you talk about the insurmountable challenges with respect to ensuring that the transmission expansion it needs is constructed in sufficient time to ensure continued reliability of its system and allow the timely development of renewable generation resources, et cetera. Do you see that there?
Yes, I do.
Have I correctly stated that?
Yes.
So do you see, is it your opinion that the transmission system that exists right now is severely, by PNM, is severely stretched?
It is being stretched, and that was discussed in PNM's IRP, and I repeated some of that in my written testimony, particularly the challenges of serving their northern load area and accessing renewable energy, where New Mexico is blessed with many sources of renewable energy, but they are not near the load centers, and so there's a need for transmission. And a great example being that getting access to very attractive wind renewable resources in eastern New Mexico.
So even though it's transmission, there are provisions in which some transmission costs are borne by the customer if it relates to the generation and distribution. Is that a fair statement? That are not FERC regulated?
Oh, now I'm confused. So you've shifted.
Let me rephrase the question. For transmission upgrades that would be required, are there circumstances where that would be under FERC jurisdiction only?
If if transmission upgrades are for like generation interconnection, then typically the FERC tariff and specifically the generation interconnection provisions of the FERC open access transmission tariff.
Sorry, connection provisions of the
FERC open access transmission tariff would apply.
Are there circumstances where those transmission costs would be borne by New Mexico ratepayers?
The transmission costs can be, yes, they could be borne by New Mexico ratepayers. There is provisions that address how those transmission costs, who they're assigned to, whether they're assigned to the interconnection customer or rolled into the revenue requirement, the FERC revenue requirement for transmission service on the PNM system.
And with the current, last question that I have, with the current situation of the transmission system and the need for serious upgrades, how do you have any estimate as to how long it would take in a reasonable scenario with regard to the equipment, with regard to the facilities, with regard to upgrading to the point where it would satisfy or correct the transmission shortfalls that exist right now with PNM?
I find the question confusing because it's not really a hard number. Is PNM's identified issues. There's a need to do a long-term study to identify how it could fix those issues. And then you look at the lead times for the types of facilities that need to be added. And part of the idea of the long-term study is to really understand what I'm going to be needing and when I'm roughly going to need it. And then you think about the lead times, and that drives when you need to move forward on projects or alternatives to those projects.
And that would include prioritizing whether the new generation would be going out of state to other markets or whether it would be internal for New Mexico, correct?
The out of state is going to be dictated by the open access tariff that's jurisdictional for other decisions would be, dictated through the planning process, including the IRP in New Mexico.
Okay, Mr. Hearing Examiner, I have no further questions for Mr. Dauphiné. Mr. Dauphiné, thank you very much for the information and for your testimony.
You're welcome.
Okay, next is WRA. Ms. Beatles, you reserve 15 minutes.
I have no questions, Your Honor. Thank you.
Okay. Mr. Al, you reserve 15 minutes.
I'm sorry, Judge, you broke up. Mr. Who?
Alvidrez. 15 minutes.
Thank you, Your Honor. Just a couple of questions. Good afternoon, Mr. Dauphiné. Rick Alvidrez on behalf of PNM and PNM Resources.
Good afternoon.
And as I read your testimony, it centers around the issue of wanting to have a long-term transmission plan for PNM to look at the system from the period about 2020 through 2040. Is that correct?
That is correct.
And have you had a chance to look at the second amended stipulation in this case?
I have in broad terms. Yeah.
Okay, and do you understand that paragraph 50 of the regulatory commitments includes a detailed provision relating to a long-term transmission plan?
It does, and NMR's position on that was related to, in Mr. Gorman's July 16, 2021 testimony in opposition to the second amendment stipulation. He specifically had proposed a modification to paragraph 50 as is presented in the second amended stipulation.
Right, and I guess it's a question of timing. Is that the issue between what's in the Second Amendment stipulation and the regulatory and what Mr. Gorman was advocating?
There's a timing in that Mr. Gorman's testimony was filed after the Second Amendment stipulation was filed. Yeah, so it was,
Well, what I mean is what Mr. Gorman is wanting is something done more promptly, I guess, having the transmission plan done more promptly. Is that your understanding of what it is he wants changed?
well, I think it's probably best we look at specifically what he said.
Okay.
I have it as page 42 of Mr. Gorman's July 16th, 2021 testimony.
Okay. And that's paragraph 50, correct?
That relates to paragraph 50, yes.
And you understand that the joint applicants have agreed to this proposed modification, correct?
That is my understanding, yes.
Okay. Thank you very much. Those are my questions.
Okay, Ms. Gould, do you have any redirect?
No, Mr. Hearing Examiner, thank you.
Okay, thank you, Mr. Dauphiné. Thank you for your testimony. You're excused.
Thank you.
Okay. Is there anything else to do before breaking for lunch and returning at 2 o'clock? Okay, hearing nothing. I'm gonna take a recess till 2 o'clock. We noticed that PNM has emailed the language or the section of its proxy statement dealing with independent directors, I'm sure to everyone. We'll deal with that after the questioning from Mr. Maestas of Mr. Kump this afternoon. So until then, we're going to recess now till 2 o'clock and Mr. Kump then. Okay, we're on lunch break till 2 o'clock.
Good afternoon, David. Mr. Albright here, just checking with respect to the volume.
Yeah, you're good.
Thank you.
Have we finished all the witnesses now? We're just doing Commissioner Maestas and that's it?
That's my understanding that Mr. Kump is coming back for some additional questions from the commissioner.
All right. Hey, Jason.
Howdy. Well, I like the tie.
Thank you. Mr. Kump, would you mind saying something so I could hear your sound? You'll have to unmute.
Yes, good afternoon. Can you hear me okay, Mr. Lee?
Yes, sir. Thank you very much.
Should I turn it up some or you hear it clear?
I could hear fine, but louder is always better.
Yeah, we hear you fine too, Mr. Kump.
Thank you. I'll turn it up a little bit,
Yeah.
but we should be good. Perfect. How's that?
That's perfect.
Very good. Good afternoon, everyone.
Good afternoon, Mr. Kump.
Good afternoon.
Jason, I think I'm going to stop by Juneau on Wednesday.
Okay, I'll be around. I'm going to Cruces tomorrow, but I'll be around all week next week.
I have a top secret case I got to cover at Kirkland on Wednesday, but should be done by noon.
Oh, okay. Let's see. I got a district court hearing from 1:30 to 2, so I'll probably.
Well, if I don't see you, that's fine.
Well, I do you know how to get a hold of me directly?
I do not.
505-385-4435.
All right.
Just text me when you're heading over, and if it's before my hearing, I can meet you, or if it's after the hearing. Yeah.
All righty.
Yeah, I have a feeling that hearing could get vacated, but we'll see.
Mr. Marks, I don't know if I should point out that you just gave your phone number out on YouTube.
Yeah, no, I realize that my phone number is already out there in the
Just making sure.
either. Yeah, no, I mean, as a result of 2 political campaigns, this is the same phone number I've had through 2 political campaigns, and
Just means more business for his pub.
maybe, but yeah.
Whenever you're ready, Judge.
Okay. Let's go back on the record. Good afternoon. Thank you, Mr. Kump. Thank you for coming back for some additional testimony. We have Commissioner Maestas here who would like to ask you some questions. I admitted him. I don't see him.
He's there.
I see him.
Yeah.
Good afternoon, everyone. Joe Myers.
Okay. Okay, Mr. Kump, you understand you're still under oath, right?
I do. Thank you. Yes.
Okay. Okay, go ahead, Commissioner.
Thank you, Mr. Hearing Examiner. Good afternoon, Mr. Kump. Good afternoon, everyone. Thank you for the opportunity just to ask a few questions. Mr. Kump, in Mr. Blasquez's testimony last week, he agreed on behalf of the joint applicants to increase the forgiveness of ratepayer arrearages from $6 million to $10 million. Is that correct?
Yes, that's correct.
Further, if you recall, Mr. Darnell of PNM in his testimony noted that between the arrearage forgiveness agreed to by the joint applicants and the grant funding sources PNM is directing to its customers, he expects the total arrearages to be, and I quote, very close to wiped out. Is that correct, or is that your understanding?
It is my understanding. However, I'll admit that I was not listening in on Mr. Darnell's testimony earlier in the week or last week, I guess it was.
Understood. Mr. Kump, as you know, we get monthly reports on arrearages from all the investor-owned utilities, including the rural electric co-ops. As of July 27th, PNM reported roughly 21 million in combined residential and commercial arrearages, with over 33,000 residential customers that are facing termination or disconnection. However, PNM, well, let me back up. The Public Regulation Commission had a moratorium on disconnections because of the pandemic. And we made it a long-term order to give utilities certainty in terms of what they can expect, because prior to this order, we were basically just extending the moratorium in tranches of maybe 30 days, 30 to 45 days. But we went ahead and decoupled the governor's public health orders from the moratorium on disconnections. And that was our way of understanding the needs of the co-ops and utilities, because arrearages were mounting. And so on August 12th was the expiration of the moratorium on disconnections for investor-owned utilities. So, and I think PNM has announced that they had intended to begin disconnecting or issuing disconnection notices at about 500 customers per day. Are you? I realize this is a PNM related issue, but it certainly is related to the commitment regarding adding additional money to defray arrearages.
I'm not aware specifically of the intent of PNM and Mr. Darnell and the team there in terms of the timing of ramping up. I can say that, you know, we've had very similar experiences in the jurisdictions that we've operated in New York and in Maine and Connecticut, and have tried to be sensitive there as well in terms of the timing and ramp up. We're a little unique in the Northeast in that we have extended periods of time during the winter where there's actually a winter moratorium anyway. It's usually between sometime in the middle of November and April when it's very cold. But we've shared, I think, in the concern that PNM has demonstrated in terms of, you know, giving customers an opportunity to you know, work their way through, see if there's funding available through the state or the federal government to pay for regions that may have built up over time.
Well, you know, if the funding that the joint applicants are offering, in addition to the assistance that's out there, if in fact the total arrearage today, roughly 21 million, could be wiped out, in the words of Mr. Darnell, why not institute a voluntary and definite moratorium on disconnections, at least until all the federal funding has been allocated? The federal funding for utility assistance that's pandemic related totals around 160 million, and the state's been given until the end of the federal fiscal year or end of September to spend that. But if they can demonstrate an ability to obligate the lion's share of that, they can have the end of the calendar year to actually allocate that pandemic related relief for utility assistance. And so, you know, would the joint applicants simply just consider implementing a voluntary moratorium on disconnections if in essence all the total arrearages, the combined arrearages, would be wiped out, given the assistance that's out there and the commitment made in the stipulation?
Yeah, again, I can't speak to the direct situation there. I would have to, you know, sit down and speak with Mr. Terry and Mr. Darnell. Again, I can maybe share a little bit our views, because we are in a similar situation in the states within which we operate. And a couple of observations I would make. The first, you know, during the moratorium, there are clearly customers that it's not an issue for them of the ability to pay, but there was a moratorium, they didn't have to pay. We think for those customers, it's important that we begin to start to collect from them as we move forward. For those that truly in a hardship situation, What we've done is we have, for example, in New York, when we reached a 3 deal, we also agreed there to set aside specific funds similar to what we're doing and proposing here for our customers. But we're also very careful, and we look at providing extended payment options so that it's not an immediate burden on customers, but it could be over 2, 3, 4, 5, in some instances even longer than that, years, as a means of pushing out the immediate impact, and to your point, allowing consumers to avail themselves of whatever monies might be available in the interim. So we're not going there and knocking on the door and saying, you owe us $500 if you don't pay, we're shutting you off. We're really saying, please call us and we can help you first find available funds that you may be able to utilize to reduce your arrears. And 2, we'll work with you on a long-term payment plan, to allow you to continue to receive service. And I'm sure that that's something that PNM would be doing as well. But again, I've not talked directly to them about it, but I wanted to share with you how we've dealt with it.
Thank you, Mr. Kump. And I guess the last point I want to make on the whole issue of this moratorium, this pandemic-related moratorium, is that PNM had made about $2 million in shareholder funds available also under the banner of pandemic relief, and there hadn't been much of a drawdown on those funds. And it would be my hope that the joint applicants would continue to make available the $2 million of shareholder funds set aside for pandemic relief until they're completely expended. Because I think initially when it was made available, PNM had set a deadline for their customers to apply for these shareholder funds. And so if the commitment in the amended second stipulation, if that commitment can be combined with the commitment that's already been made in shareholder funds, I think that would go a long way to help these folks pay off their utility bills.
Yeah, no, I absolutely agree with that. And I, it's interesting because I sometimes scratch my head too when I talk to some of our folks within our customer service organization, that there seems to be sometimes inertia on the part of customers that are falling behind to call us and have, us work with them to find solutions. And unfortunately, sometimes what it takes is they get something in the mail saying it's a shutoff notice for them to call, and we urge them to call. But clearly, I agree completely. If there is some of that inertia and it's not, the funds aren't being used as quickly as we would have anticipated, I see no reason why we couldn't continue to have those funds out there and available as we work with customers to find solutions to their specific situation.
Thank you. Let's turn to economic development. I know a lot's been discussed about some of the commitments that have been made to date with respect to economic development. Our staff still disagrees with the commitments that have been made. I believe staff requested a total amount of economic development, I think in the amount of 114 million, but over a 20-year period. Mm-hmm. And so I'm trying to wrap my head around that and try and normalize it, perhaps for maybe a 10-year period. Mm-hmm. But my point is, there is a difference in what staff thinks would be a fair and just commitment for economic development relative to what's in the amended second stipulation. And thank you for continuing to add, I think, to that total commitment. Right. But our staff, despite, I think, some of the recent concessions that have been made, still feel like the total is significantly insufficient. And I'm quoting Mr. Reynolds. Why do you feel that what's been committed thus far for economic development is sufficient?
I would say a couple of things. So one, first of all, we would look at it kind of in the entirety of the package, including the rate reduction commitments and other commitments we've made, which now aggregate to, I believe, around $125 million when you look at the rate credits as well as the economic developments. And the other piece that I think really isn't, in my opinion, giving significant weight is the commitment to jobs. And I know there's been several testimonies through this case around the value of the commitment to jobs. And I think one of our witnesses used a multiplier that says for every job, between 1 and 2, closer to 2 jobs are created indirectly. And quite frankly, I've seen studies done on a national basis. And one of them said that when you look at all the sectors in the US economy, the sector that has the greatest multiplier effect of jobs is the utility sector. And they estimated a number as high as 8 to 1. And so I think there's an aspect here in terms of the job commitment that really is being undervalued. We made a very similar commitment in Connecticut 5 years ago in that proceeding when we acquired UIL Holdings. And we've testified that ultimately our commitment was 150, but we've added over 300. I think the number is 329 direct jobs and the multiplier effect of that. And that's clearly our view here in New Mexico. As I testified, we really view this transaction as one of growth, and we see tremendous opportunities to grow here, particularly from a renewable perspective, but also from a networks perspective, because our view is just as important to decarbonizing is the development of new renewable resources. It's having a network system that will enable that, whether it's different forms of distributed generation that requires now a system that can flow 2 ways and be able to monitor that, to long haul transmission, because we know that resources such as wind and solar don't necessarily appear where load centers are. So I would just respond back that I think people have really underestimated the value of the commitment around jobs, and we view that in totality as a package.
Thank you. I want to talk a little bit about our electric grid here in New Mexico. From an outsider's perspective, how would you characterize, based on your expertise, how would you characterize briefly New Mexico's grid?
I have to confess that I don't know a lot about New Mexico's grid. I'm not an engineer by trade. I'm my finance background. What I can say is this, and I know there's been discussions, and we've committed to work with the state and neighboring states to think about the concept of an RTO, or we call it in New England an ISO. We have seen tremendous value in regional transmission planning because, as I said earlier, where generation can be built and where load is normally doesn't just happen within a given state. And so regional transmission planning, I think, is critical to what we're trying to do in terms of decarbonization. So I'm really pleased that we will look at that, and we've committed to spend dollars to look at that, so as to really have a long-term view on how we optimize the network within the region and the transmission in the region to allow not just New Mexico, but all regional states to decarbonize.
Well, our state, as you may or may know, recently passed the Grid Modernization Act. And I think it was basically a way of saying our grid it's antiquated. Certain feeder lines in the PNM service area are already at capacity and can accommodate any distributed generation, any rooftop solar, particularly the La Cienega area in my district. I've had many calls from constituents complaining that they put rooftop solar, but they can't interconnect.
Yeah.
Now, I think the upside, Mr. Crump, is that I think it's only about 4% of the feeder lines through PNM's service area are at capacity. But nevertheless, it's showing signs of a need for investment. Because I think, as I recall, some officials from PNM were saying, we're in the business of electric service, not so much economic development. And so as an engineer, I'm an engineer, not an attorney, I feel investing in our electric infrastructure, I think, is more pertinent to the business of providing reliable electric service. And so I bring up grid modernization because in that law, well, let me back up. In your direct testimony, and this is your direct testimony in support of the second amended stipulation. It's page 39. Exhibit 13, page 39, lines 4 through 6. And I'll give you a minute to find that.
Yep. That's the June 18, correct?
Yes. I want to quote you. You said, Avangrid can also provide financial assistance in the event of any utility's need to raise money for projects such as grid modernization or significant new transmission projects. What did you mean by raise money?
I'm sorry.
Go ahead, sir.
No, what we're really talking about there, and let me just step back for a minute to your comment earlier about the status of the grid in New Mexico. I would just say New Mexico is not alone in that regard. And we have similar struggles in upstate New York and in Maine, where the service territory is very rural. You have very low customer density, and you have a lot of interest in hooking up distributed forms of generation, and the system was just not designed for that. So what I meant by my testimony there is that we're experiencing that as well. We're working on solutions to that now. And we think through the sharing of best practices, we can get solutions for all of our utilities to address this issue. And given the financial wherewithal of Avangrid, we have the balance sheet to be able to invest. You know, we're investing over the next 5 years. We're estimating that we're investing $20 billion. About half of that into actual renewable generation, the other half into the networks, which is about double what we've invested the prior 5 years. And this is the exact reason why. And you know, it's created some difficult challenges for us. I'll admit, we have some customers and some community solar developers that are not happy with us right now in certain jurisdictions. I testified that when they opened this up in Maine, within the matter of months, we had 2,000 megawatts of applications for community solar on a system that doesn't even have a peak load to that degree. So it creates challenges. And my point of all this is just that I think together we can work on these issues because it's not unique to any one jurisdiction. This is a national issue. I know they're having the same issue in Massachusetts, and Avangrid has the resources to be able to address that.
I bring up the Grid Modernization Act and the dire need to invest in our grid because as a consequence of the Grid Modernization Act, the Energy and Minerals Department here in the state was the lead agency in convening a series of working groups. And so I say that in that we're just at the front end of implementing this legislation, but investment is going to be a key.
Yep.
And I highlight that yet again because there's a grant program within the Grid Modernization Act, and it's meant to fund eligible projects proposed by municipalities and county governments, state agencies, state universities, public schools, post-secondary education institutions, Indian nations, tribes, and pueblos. Right now, there is no funding in that grant program.
Mm-hmm.
And from my perspective as a commissioner and a citizen of New Mexico and a user of electric service from PNM, that would be a golden opportunity to truly make an indelible impact in catalyzing the entire grid modernization effort and join in.
Pardon me, Commissioner, indelible impact in
grid modernization. But the state needs help. We lack resources to truly, implement this planning effort. We are doing parts. For example, the Public Regulation Commission, we're updating our interconnection manual, but it's not in any evidence, but there is a sequencing diagram that has all these efforts that need to be done with certain assignments to different stakeholders in government. And it would be my hope that joint applicants would be familiar with grid modernization and consider making an investment more specifically in capitalizing this grant program that's called for within our Grid Modernization Act, and empower all those stakeholders that are eligible to partake in this grant program.
Well, certainly if we were fortunate enough to have this deal close and we could work with the folks at PNM, we would be more than willing. Because as I said, we're already working on that now in our utilities to work together to find solutions. And thinking through as you were talking, I would think that you could probably argue that some of the monies that are available through the economic development, the $50 million in economic development funds, could go to these types of things if we had specific projects for specific universities, municipalities, whatever the case may be. So I think clearly we have the balance sheet. We'd love to work with PNM on that, and I think monies will be available to push that because it's needed. To your point, it's really needed.
Thank you, Mr. Kump. You know, one thing that I've learned as a commissioner in a very short period of time is that demand management, I think, is one of the most inexpensive ways to reduce energy use. But I think even better, it empowers the ratepayer through energy efficiency, through weatherization, through real-time knowledge of their energy use. And I believe that really is the next frontier for our state, is empowering our ratepayers through effective demand management. And so I want to focus specifically on weatherization. In your second amended stipulation, I think there's an agreement to commit $15 million in total over a 5-year period at shareholder expense to increase cost-effective low-income energy efficiency and weatherization. Right. Is that your understanding, sir?
Yes.
Mm-hmm. Are you aware that there's many homes, particularly homes with low to moderate income ratepayers, that don't even qualify for weatherization because of more significant health safety issues, mold, faulty electric wiring, leaking roofs, and so I say that because it doesn't make sense to pour more money into weatherization if we see more and more ratepayers would be ineligible. There'd have to be a deferral for those reasons that I mentioned. And there are programs out there. One program that I think is a model program is in the state of Michigan. They invest over $23 million in weatherization, but that also includes what they call weatherization deferrals, fixing roofs, electrical wiring, mold. Mm-hmm. We have our own program here, excuse me, in New Mexico. That budget is about $9 million. And unfortunately, PNM only contributes about 2.5% of the New Mexico weatherization program. So I say that because I'd like there to be a focus in greater investment in weatherization with a more specific emphasis on addressing these homes that are going to experience deferrals because of more dire repairs. And Michigan's a bigger state, but I think we likely have a higher demographic with low to moderate income ratepayers. I know we have a much older housing stock. And so I think here's another opportunity to perhaps invest more in demand management, empower the ratepayers, and begin to chip away at these deferrals, these weatherization deferrals that are going to interfere with an expansion of the weatherization programs. So do you agree? Do you understand where I'm going?
Absolutely. And Commissioner, as you're speaking, it's striking to me just the similarities in the demographics that exist in New Mexico and upstate New York and Maine. I mean, we have an inordinate amount of our customers in Maine and New York that are below the poverty line, and we have specific programs that we have for them, very similar to, I think, what you're explaining here. So absolutely, I think this is another area where, we have very similar demographics and I think probably very similar programs, and we can learn from each other in terms of what's worked and what hasn't, and put resources to bear to this issue.
I referenced the weatherization program managed by the New Mexico Mortgage Finance Authority, but the specific name is the New Mexico Energy Smart Weatherization Program. And I invite you to take a look at that. And the total
I will look at
funding.
that. Yes.
Thank you.
Thank you for that awareness. I appreciate it.
So I have to come back full circle into, staff's disagreement with the difference in economic development investment as committed thus far in the amended second stipulation. And my rationale is that maybe that difference can be made up in other ways, through investment in grid modernization, through additional investment in weatherization, and specifically pre-weatherization repairs or weatherization deferrals. And I invite you to take a look at that, because to me, that would be just as satisfactory, instead of, striving to meet what our staff is asking for. There are other ways, there's monetary equivalence where perhaps we can meet, maybe not, maybe in the middle. So I ask you to consider that in the context of that key disagreement in what our staff expects in the way of economic development and what's in the stipulation.
We will do that. I'll take that back and we'll have a discussion on that.
All right, I'm almost done, Mr. Kump. I have to bring the issue of El Cabo. Staff has sought to perhaps get more discovery in terms of what is the actual operating capacity of the El Cabo plant. And I believe in your testimony, your July 29th rebuttal testimony, joint applicant exhibit 16, page 14, lines 9 through 14. Again, it's the July 29th rebuttal testimony, JA exhibit 16, page 14, line 9 through 14.
I have it here in front of me.
Okay, if I may, let me just read a quote from that. Avangrid and its affiliates will not oppose the initiation of a commission inquiry into El Cabo, and will actively participate in any such inquiry, and will provide information related to El Cabo's operating capacity and rights of way if such information is requested by the commission. Avangrid will also happily work with staff on any proposed prospective regulatory changes related to location control and right-of-way determination. So as a commissioner, I don't understand this back and forth. I believe the rated capacity was maybe 2 megawatts under the 300 megawatt threshold that triggers location approval of the PRC. Now, whether other people might see that as being cute, it's under 300. My point is, why not just provide the information, to the PRC and avoid a formal investigatory docket? Tell us what the actual operating capacity is, just to allay concerns of staff, instead of having us, again, open a formal investigatory docket. Why do we keep, going back and forth on this? I mean, maybe it's a PNM issue, but I think it's an Avangrid project, I believe.
Yeah, I have not been, Commissioner, incredibly close to this on the renewable side and this project, but I can commit to you that I will sit down with our folks in our renewables business and better understand this issue and figure out a way to provide the information that staff is looking for. I think our comment here more was rather to look in the rearview mirror retrospectively back. Let's we're more than willing to sit down and figure out exactly what we should be doing prospectively to ensure that we don't have a situation like this again. But if there's still an interest in getting the information associated with this El Cabo project, I'm sure we can work with staff to work through that.
Thank you, Mr. Kump. I wanted to talk a little bit about Avangrid's involvement in political action committees, but I want to speak to you about the experience that we've had in the state, and perhaps you can understand my sensitivity and concern over this issue. There was 2 political action committees that were established here in the state last year that were in support of a constitutional amendment to change our Public Regulation Commission from elected to appointed. And the political action committees were funded through anonymous donors or dark money. In fact, there was an ethics complaint. It was the first complaint that was processed by our new state ethics commission. And the ruling was against the individuals that were supporting the political action committee.
Mm-hmm.
But of greater concern, Mr. Kump, is that there was heavy speculation, and I don't engage in hearsay, but we never did get an affirmation from PNM that they did not participate or contribute to this political action committee that was in support of this campaign to pass the constitutional amendment to change our commission. And so you can see we're all, and you must know, Mr. Kump, here in the state of New Mexico, particularly Santa Fe and parts of Albuquerque and Las Cruces, there's a very progressive community out there that's very aware of current events, and they're curious. And this is one of the major sources of curiosity from particularly the progressive elements of our community. And so when I read, and this was in your July 27, 2021 supplemental testimony, JA Exhibit 15, you discuss CMP's involvement with the Political Action Committee Clean Energy Matters,
right,
which you also addressed in this hearing. Is that correct?
Yes.
In your oral testimony, in your July 27 testimony, or July 27th supplemental testimony, you acknowledged that CMP provided funding to a PAC to help defeat a measure that was opposed by Avangrid. Is that correct, sir?
That's correct.
So, with Citizens United, it's your right, to participate, in these campaigns. But I wanted to ask you on the record, should this merger go forward, would you at least commit to disclose such political action contributions to sway any state legislative efforts, ballot initiatives, despite the fact that the laws of New Mexico do not require it?
Mm-hmm. Commissioner, if I could give a little background on the state of Maine and the PAC that existed and the history there. I think it might then give you a sense for why we created the PAC and our views on PACs in general. So much of this noise started when we won an RFP that was administered by the state of Massachusetts for clean energy. And the project that we won was a transmission line that would transport 1,200 megawatts of clean energy associated with hydropower that is generated by Hydro-Quebec. And it would come through the state of Maine and into Massachusetts for the entire New England ISO region benefit. And there had been a project that had actually initially won that RFP. It was called Northern Pass. And Northern Pass was being developed by a company called Eversource. It's another utility in New England. And that ultimately was defeated by dark money that was, quite frankly, it was the fossil fuel generators in New England that stood to lose millions of dollars a day when this clean energy came in the system and suppressed prices for the region. So they defeated Northern Pass. We became kind of the second winner, and instantly that dark money came to Maine to try to kill our project. And they've taken numerous steps. Every permit that we have received over the ensuing several years, they've challenged in courts to the highest court possible. And NextEra, the three primary companies are NextEra, Calpine, and Vistra. Those are the three that have fossil fuel generation in that region that stand to lose the most. And they've challenged everything. One of the things they did is there's a referendum process in Maine. And the first referendum that they put forth for the citizens to vote on essentially said it would require that the commission in Maine, which had issued its permit called a CPCN for the project, would have to reverse that. And they started throwing out all sorts of falsehoods about the project. And we felt we had to defend ourselves. And the process in Maine is such that if you're going to defend something that has become a citizens initiative, you have to set up a PAC with full transparency. And so that's what we did to defend ourselves against this attack on the project and the falsehoods that were being thrown out there. What we found ultimately through our PAC is that the opponents, there was fraud in the process of them collecting signatures, and signatures were thrown out. Ultimately, that process did result in them having received sufficient enough signatures to put it on the ballot for, this would have been November of this year. But we challenged that referendum on a constitutionality basis to the highest court in Maine, and it was thrown out. Subsequently, within months, these fossil fuel generators funded a second referendum, which now is on the ballot for this November. So this has been going on for several years. And again, I will say that, yes, we've had PACs on this, and quite frankly, now we've had to commit a PAC because certain legislators are attacking the company with respect to government controlled power, basically having the government buy all the utilities in the state of Maine. But we do it very openly and very ethically, which is, I will say, is different from the opponents. They are in front of the ethics committee now for violations of ethics, and they continue to stonewall our committee in terms of not giving them information. So what I would say to you is this: yes, we've used them. We didn't have a history of using them at all up until the last 3 years. We use them in a very open and transparent manner. And what I can assure you is that if there was ever an instance in New Mexico where we felt there were falsehoods being put against PNM, and we needed to defend ourselves, and the process required to do that a very transparent manner through a PAC that discloses all its funding sources, we would certainly do that again. But we are absolutely transparent and have been in everything we do in that scenario that was there in Maine. And I apologize for as long as I've taken on this answer, but I think you need to understand the history here as to how it evolved to where we are now in Maine.
Thank you, Mr. Kump. My last issue involves collective bargaining and pensions. We have here in the state of New Mexico very strong activity and support for collective bargaining and unions here. I wanted to turn your attention to JA Exhibit 13, page 14.
Which was 13 was which one? That was June 18th.
Direct testimony in support of the second amended stipulation.
Yeah. Okay.
Page 14, lines 5 through 10, if I may, let me just quote you. Commitment number 22 provides that joint applicants will honor PNM's current collective bargaining agreement and will negotiate in good faith regarding a future collective bargaining agreement. In addition, within 6 months following closing, PNM will study the pension for union employees to evaluate whether the pension is fully funded and will work with the union to ensure that the pensions remain fully funded.
Mm-hmm.
I mean, I guess my question is, why wouldn't an assessment be done beforehand, before considering this formal merger and an application regarding the pensions?
Yeah. So let me start by saying this is IBW. We have a very strong relationship with IBW. They are involved in each of our utilities. We also have a very strong relationship with them at a national level. They've been supportive of work we're doing, for example, on our NECEC project, which is the transmission line in Maine. And they've been very supportive.
In our supportive
of our transmission project in Maine, NECEC. And they've been supportive of our first offshore wind farm, Vineyard Wind, which we hope to start construction later this year. So we have a very, very strong relationship with them, work very closely with them. And the issue of pensions obviously is a very important one for them, making sure that they're represented well, all of those employees, and that they have security in terms of their pension. My understanding on this is that many pension plans, given the very low interest rate environment we're in now, are underfunded. I can remember back 30 years ago that we had pension plans that were 20 or 30% overfunded. But as interest rates decline, the discount rate goes lower and it creates a larger liability. So from my perspective on this, we're just committed to say, look, we're going to continue to use very reasonable actuarial assumptions, looking at what the funded status is. And if that means more money needs to get funded, we do that. And that's our practice now in all of our jurisdictions that we're in, where we work directly with the IBW.
So I guess I wasn't clear on this commitment. Why wouldn't the joint applicant stipulate right now to ensure that the pensions are fully funded without knowing what the assessment, what the outcome of the assessment is, or waiting until the current agreements have to be renegotiated? I'm not clear, or maybe you are making that commitment.
Well, no, I think I understand what you're saying, and the wording maybe is a little confusing. Really what we're saying is, because you have to do an actuarial evaluation every year, right? And based on that, you get a funded status and you determine what kind of funding you'll make. And I don't know the details specifically here. I always assumed that maybe there was a question around maybe some of the actual assumptions that are being done. Really, what I would commit as Avangrid is, as soon as we get done with this transaction, we will look at and do an actuarial evaluation, look at reasonable assumptions, and determine are we funded to a level that's appropriate. And if not, we'll ensure that monies get put into the trust for the benefit of employees. That's our commitment. We do these all the time in terms of these actuarial evaluations. Many companies, as you can imagine, when you think about assumptions around what's the return going to be on your assets, or what's the discount rate, the interest rate assumption going to look like long term, people have differing views on that. And some take a very aggressive approach. And if you take an aggressive approach, it makes the plan look funded better than probably it truly is. And some people take a more conservative approach. We look at this every year. We make sure that, and our actuaries help us with this, that the assumptions we're using are reasonable and in line with what companies in general are using. And then based on that, we come up with a funded status and determine what needs to get put in. And that's what I would commit to you we would do in this instance.
Thank you, Mr. Kump. Basically, that concludes all my questions, Mr. Hearing Examiner. Mr. Kump, thank you for being available, and thank you for the opportunity. Mr.
No, thank you very much. I appreciate the opportunity to speak. And as always, as we move forward, if there are ever any questions, never hesitate to reach out.
Thank you.
Okay, Mr. Haverly, do you have any redirect on that?
Thank you, Mr. Hearing Examiner. No redirect.
Okay. Well, then that concludes the testimony in this case.
Mr. Hearing Examiner Shernauer, are we going to be able to ask any questions in response to Commissioner Maestas's question?
Well, ordinarily there is no follow-up on the questions asked by other parties. I mean, everyone's had the time allotted to them for their own questions of every witness, and you've had time allotted to you for your questions of Mr. Kump. So, I mean, ordinarily, this is the time now is for redirect, not for further cross of this testimony.
I understand that. I don't have that many questions. I only have 2 or 3, but I think that specifically regarding the PAC, this question was asked of a witness. I believe you sustained it with respect to Mr. Long, but then I also think that Mr. Kump response to Commissioner Maestas around the PAC is incomplete and potentially inaccurate. And I just think that the record should be made clear about what the actual situation is. And Mr. Kump did testify about this.
Yeah, but we have 20 parties in this case. Are you asking me to let everyone do cross-examination now about what has been asked by the Commissioner Maestas? Is that what you're suggesting?
If no, I don't know how many parties want to ask a question, but I want to ask 2 or 3.
I would want to ask more questions too if Ms.
Who is speaking?
I'm sorry, Mr. Court Reporter. This is Ms. Zur for the Coalition for Clean Portable Energy. And if we're going to open this up to cross-examination, then I would like time also. And I'm not asking for time. I'm just saying it would be fair to give other parties time at this point.
Well, how many other parties have an interest in this? So just Ms. Nanazi and Ms. Zur?
Well,
Okay.
Mr. Hearing Examiner, I agree with you, and I don't think we should be going into this again, but if we do, I'm just asking that I also be given time.
Okay, well, we're not going to go into this again. Everyone had their opportunity to do cross of Mr. Kump, and so, you know, we're done with that. So we're going to move on, and we're going to talk about the remaining items that are at issue here. Let's see. One of the items was the
Excuse me, Mr. Hearing Examiner, so am I excused? Should I drop off?
Yes, you're excused, Mr. Kump. Thank you.
Thank you very much. I appreciate it.
Okay, one document here was the what I requested from PNM in terms of identification of board members at PNMR that are independent, and PNM Council provided a document that indicates the status of those board members, and I'm going to offer that into evidence as Commission Exhibit 12. And is there any objection to that?
Yes, New Energy Economy objects, and I wrote to everybody about that. I believe that the document should include page 5 through 21, not just the pages that that PNM has offered. And I stated when I wrote to everybody why, I believe it goes to questions that were asked throughout this hearing. The document is about the PNMR board. It not only talks about independent board members, but it specifically, if you go on to some of the other pages, talks about that the PNMR board has 9 independent directors, 9 directors, 8 of whom are independent. 1 is Pat Vincent Colon. It talks about the lead director. It talks about some of the questions that Mr. Haverly had posed to different people, witnesses. And that was about how much compensation that they receive. And there's a whole bunch of other information, but particularly about the duties of the PNMR board independent directors, including the requirement that there be independent board members in subcommittees. And I think some of those other details and explanations by PNMR about why that's important is specifically indicated on those other pages. And the joint applicants, but particularly Mr. Alvidrez, has repeatedly accused New Energy Economy of incomplete information. And we believe that having page 5 through 21 of this document would satisfy that completion.
Are there any other objections?
May I respond, Mr. Hearing Examiner?
Yes, Mr. Hearing Examiner.
Well, let me hear from Mr. Albright first.
Mr. Hearing Examiner, we would, I've looked through the entire document as well once we had the few pages. And I think it's consistent with Ms. Reno's testimony and our proposed for the structure of the independent board as a compromise with regard to the lead independent director with specific duties, independent directors meeting regularly in executive sessions. I don't think it's inconsistent on. I think it would give a more complete picture, particularly in light of the cross-examination that was given to Mr. Darnell and the cross-examination yesterday of staff witness John Reynolds, who indicated he didn't know the status of the PNMR board or the independent directors. And I think it just gives a much more complete picture. We would just ask that you amend to include the pages that were submitted, including pages 5 through 21. And I think that would give a complete picture.
Mr. Alvid.
Yes, Your Honor. You asked for some specific information, and we identified a page out of the proxy that would provide very succinctly the information that you requested, and a little bit more, as a matter of fact. And we did include another page that talked about, the determination of what a description of what an independent director is. Now, what I'm hearing from Ms. Nanasi and Mr. Albright is that they want this entire document to support their further arguments that they could have made during their case in chief. Again, this is a public document. It's something they could have pulled off. In fact, Ms. Nanasi obviously did pull off the internet this document, and this wasn't intended to be used as evidence. And we will not have had a chance to address the arguments that are going to be made with respect to this matter. So we believe that what we submitted and what you're proposing as Commission Exhibit 11 addresses the specific question that you asked, and it should be limited to that.
Yeah, I'm proposing that the Commission Exhibit 12.
I'm sorry, Judge, you broke up. Can you start again?
Yeah, I'm offering this as Commission Exhibit 12. And I'm admitting this excerpt that was presented by PNM as Commission Exhibit 12. I asked for an identification of the independent board members of PNMR. I did not ask for anything else about the board of PNMR. The requests of the objections of Ms. Nanasi and Mr. Albright are based upon their interest in getting more information about the PNMR board into the record at this time. That information could have been put into the record by Ms. Nanasi and Mr. Albright in their direct cases or in their rebuttal cases, but they did not do that. And we're not going to go down the road of having additional testimony and argument on new issues at this time. The hearing is coming to an end. Everyone has had an opportunity to address the testimony, the pre-filed testimony, the prepared testimony that was submitted in accordance with the procedural schedule. And we're not going to have a further set of supplemental testimony about additional issues. This is an exhibit just to identify and clear up a question that was left unclear during the hearing in this case. So I'm admitting Commission Exhibit 12 as in these pages that were submitted by PNM, and I'm going to upload this exhibit to Dropbox, and we'll move forward. The next issue I wanted to address was the exhibits 54 and 55, NEE exhibits 54 and 55 that were left open for admission this morning. Ms. Nanazi, have you made the further, I guess, deletions to denote to reflect the testimony and other documents attached to the testimony as exhibits that I ordered stricken?
Yes, there is a revised NEE Exhibit 54 with the exact submission on July 16th. And then per your order, it is now blacked out. And that is up as revised NEE Exhibit 54. And 55, I believe you stated that you were going to look to see if it complied with your order, which I believe it did. And so we haven't changed that exhibit.
I did look at Exhibit 55, and I agree that that document reflects the items that I ordered stricken. I don't know, does PNM have a comment or further review of that?
No, Your Honor, we had just noted it had been altered from what was originally filed. That was the issue, is that what the pre-filed testimony isn't just simply struck; it's been reformatted and creates difficulties. I have not noted that it has changed in substance, but I also haven't done a word-by-word comparison.
Okay, well, I have, and Exhibit 50, NEE Exhibit 55, I'm sorry, seems to reflect the stricken portions of testimony and exhibits that I ordered. So NEE Exhibit 55 is admitted, and revised 54 I can see one of the changes that I thought was necessary.
There's only 4 places, and if we want, we could go through them very quickly. I believe that it's on page 9 and page 10.
Mm-hmm. Yeah, I saw that one. That one looks fine.
Page, I believe it's 73, if my memory serves me. And that is also exactly as Your Honor ordered. And
there was a need to delete quite a bit of Mr. Berry's testimony, his affidavit.
Yeah, but I was first going in order, and I believe that the issue that you had also was on page 73 in the testimony. So it was on 9 and 10, and then on 73, we did what you said, which was to black out 15 through 18. And then in CK, and then we did also black that out in the list of exhibits for CK3, if you see that. And then on CK CSK 1, you said we could leave page 1 and 2, then everything else is blacked out until I believe page 18. And you allowed that from line 8 to 22, which is what we did. And then the only other thing that you said was the last thing, which is we have to scroll down quite a bit after this Liberty report. So then it's CKS3, which is completely blacked out now. It's there, but it's blacked out.
Yeah, which, in Dropbox, which page was that?
I'm trying to get to it. It's like 100 and
See it, it's 238. Okay, I see that that's been blacked out.
Mr. Nassi, can you spell Barry?
BERRY. So it's actually 238 and 239, Your Honor, has been blacked out. According to your ruling, all of those are exactly what you had ordered.
Okay.
So I moved the commission of revised me exhibit 54.
Okay, so revised NEE exhibit 54 is admitted. Okay, the last item that I had here is to talk about schedules for post-hearing filings here. I know that, obviously I know that the parties, most if not all of you, are involved in the Four Corners case that's going to hearing, I think, starting on August 31. So I assume that's going to interfere with your ability to do a full briefing on this case in the normally required time. Am I hearing that right? Am I assuming that right? Okay, I see heads nodding.
I think that's probably a safe assumption, Your Honor.
Yeah. Okay, well, I just want to be clear about what I'm going to be doing here. My recommendation to the commission is going to be based upon the record to date. It will not consider any changes that may be negotiated after the end of these hearings. So what I'm looking for is what I'm going to be looking for soon, either by the end of next week, August 27, or by August 30, are statements of position on the second amended stipulation as they are reflected in the current record, and specific sections of the regulatory commitments that each party's positions on each of those regulatory commitments on which each party has taken a position, and citations to the record where those positions have been stated. That's not a brief. That is just an indication of what your positions have been through the end of this hearing process. And then briefs, I'm proposing these dates for briefs. Briefs would be due September 21, 1 week after the close of the Four Corners hearings, and then response briefs by September 28, 1 week after that. I'll issue hold on a second. I'll issue an order that is, states this more clearly about what it is that I'm asking statements of positions for. I'm not asking parties to give me a statement of position with respect to anything that they haven't taken a position on. I just want to know what your positions are on issues that you have taken a position. Any comments about any of that? Does that seem reasonable?
Mr. Hearing Examiner, this is Kelly Gould for NM area.
Mhm.
Would it be possible to get 10 days for the response briefs?
The response briefs. I think 7 days for the response briefs is fine. I think the main briefs would be the more difficult part, but why do you need 10 days for the response brief?
It's just it's a busy time. There's going to be a lot of briefs that we're going to have to read and look at, and we just want to make sure that we have adequate time to analyze the parties' positions.
What do other parties think? Mr. Albright?
Yes, Mr. Hearing Examiner, Jeff Albright. I think the time you have is adequate since we're only talking to the position. And I think the times, I'm okay with the 21st and 28th.
Anyone else?
Yeah, this is Brad Borman with staff. I'll be frank. I don't like it for my own personal reasons because I have other plans then, but we will do what we're required to do.
Anyone else? Okay, well, I'm going to stick with this. I mean, we need to get a decision done in this case. We need to get a decision done. So I'm going to stick with those dates that I outlined when I just described them. Is there anything else we need to talk about before we close the hearing? Ms. Gould?
Mr. Hearing Examiner, I have two questions. One, would PNM make the transcripts available to the parties, or how is that going to be navigated? And two, did you set a date for when you want our position statements filed? I didn't record that. Thank you.
Well, the transcripts are being posted on the commission's e-docket. And in terms of the date for the statements of positions, I said either the 27th of August or the 30th. I don't know if with the Four Corners hearing starting on the 31st, I don't know if people prefer the 27th or prefer the 30th. I mean, I imagine you're all going to be busy uploading things to Dropbox that weekend. So I'm thinking maybe the 27th is probably better for you all. I don't know. Tell me what you all think. I don't really care too much.
Mr. Hearing Examiner.
Go ahead.
Yes, sir. I would prefer the 27th, just for the very reason you mentioned. With the other case going on, we'll be crushed at to get everything done for that proceeding. So I think the 27th makes more sense.
I prefer the 30th because I'm going to be out of town.
Who is speaking?
I'm sorry, Mr. Lee. Sydney Beatles with WRA. I prefer the 30th because I will be out of town Wednesday through Friday of that week and may need the weekend to develop the statement of position.
NM area, Kelly Gould, we also prefer the 30th. Thank you.
Anyone else? Okay, I'll make it the 30th. If people want to file something on the 27th, they can, but the deadline will be the 30th.
So, Mr. Hearing Examiner, I have.
I can't tell who's speaking.
Mr. Lee, I'm sorry, this is Sydney Beatles. I do have some questions about the statements of position, and if you, let me just ask the first one, and if you tell me you're going to explain all that in your order, then that's fine. I don't need to go on, but I presume that you want them from both signatories and non-signatories, and to the extent that non-signatories have proposed modifications that Avangrid has since accepted, Do you want signatories' position on that? Is that the kind of statement you're going to be looking for?
I want, I want your final position. Now, if it's based on what you've heard based on what you've heard at this hearing, okay?
Okay.
What it's based on. And if you're responding to something that Avangrid, but it's got to be based on evidence that you've presented in this hearing, okay? That's what it's based upon. It's not based upon a retroactive review of the hearing now or tomorrow. It's based upon what your view is today of the evidence that's been presented. Did you have any further questions, Ms. Peters?
That's it.
Okay. Okay, any other questions?
Your Honor, Rick Alvidrez, I have one question. There is a relatively quick turnaround time for proposed corrections to the transcript. Can we make that deadline contemporaneous with the opening briefs?
Yeah.
Thank you.
Okay, is there anything else? Okay, well, thank you all for your participation and cooperation in this hearing, and the hearing is concluded.
Thank you, Mr. Herring.